Yes.
I will mention item number 19. Actually, for the recommendation. Only for today. Thakur examination will be yesterday.
Item 19 is not it?
Yes, Lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks.
Hello, Lord.
May it please your lordship, I beg to mention item number 3, 4, and 5, your lordship. It may be adjourned for the day, your lordship.
Sorry. Nothing survives in this request. Prayer stands rejected. These are 2014 matter. Yes.
Obliged.
PPA is it?
So, oh my lord, your lordship's earlier order is at page 33, man.
Scan copies.
Alright.
She has been examined.
Victim is examined already.
See, earlier that was the ground.
That's my
Call for the scan.
and notice.
A notice to the
Notice.
informant. Notice to the informant. Registry through steps to be taken in terms of notification number so and so through the office of the public prosecutor.
Police.
Bail keta korilo ni hote. For example, give a date, scan copies.
Notice to serve. Alright.
Lordship, matter may kindly be taken after some time. My senior Mr. J. Ahmed is on his way.
Where is the informant? Heard the learned counsel for the petitioner. Record is received, Mr.
Yeah, Kamala, this is the CD is there. Man.
CD is there,
If,
but earlier rejected or what?
yes, I didn't.
Where is the order of rejection?
Let's kindly see the page 15.
One
Oh no,
five.
my lord, this is the interim order earlier granted. That is why both cases.
So I have granted interim
Yes.
somewhere.
Yes.
Where?
Interim granted on 6/6, my lord.
Which matter?
In my lord, item number, yes, 12, audit circuit, audits, audit circuit.
Statements recorded.
Statement recorded, my lord, but materials are there. Again.
Have you seen?
Because they have, in interim, my lord, they have admitted that. That is what the crux is there.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on next Monday.
Yes.
And interim order, if any, stands shall continue. কোনটো চাই লব সি বহুত কোন দুইটাতে ইন্টারিম নাথাকিব পাৰে চাই লব Tuesday, not Monday, Tuesday.
May it please your lordship.
Yes.
This is an NDPS matter, my lord, where there are two accused, my lord. The case is on trial, my lord. And she has been in custody for less than just 3 years, my lord, just 2 months less, my lord. And she has been released on 11th of March 2024, but bail was granted on 7th of February 2024. The main accused, my lord, has already been granted bail, a copy of which is annexed at page 37. In this case, my lord,
How many witnesses examined?
11
Total 11
witnesses
witnesses
examined, my
already
lord.
examined.
And since
11
last,
examined
since
when
last
on
year-
31/8/2020.
since
Thereafter,
since last year, August,
Oh.
there has been no examination. No witnesses have been examined since last year, August. Now we are just more than 1 year, no examination of witness.
Elsewhere, I have like not.
I have seen that.
Status report.
Hmm?
Because my lord,
What
this
is the
petitioner is
name,
on-
what is the name of this lady?
My lord, she's Hatneling Cookie.
my lord. Since she was outside, my lord, so on bail, my lord, so uh, on treatment, my lord, that is why the case is pending. Completed.
And even if you go by the evidence, my lord, till now, so many witnesses have examined. No
Where
one,
is the FIR? Where is the FIR?
the FIR is at page 18,
Page
19, my lord. The effective at page, the page 22 is a typed copy, my lord.
page
Page 22 is a typed copy. 21 is the FIR. With reference to the subjects cited above, I have the honor to report that as per confidential information, I, along with team of Sadka police station staff, accompanied with Crime Branch Guwahati City Commissionerate, conducted search and raid in the rented house of owner Srimati Ila Kumar, so-and-so, Panjabari near so-and-so, where residing the below noted accused person since 8 months and continuing illegal drugs business over the greater Guwahati for the personal benefits. Accordingly, house has been searched in presence of local public and recovered and seized
where is
23.
the, where are you reading?
My lord, page 21, my lord.
Page 21.
21. I'm sorry, my lord.
How can I read this?
May I read it slowly, my lord? With reference to the subject cited above, I have the honor to report that as per confidential information, I, along with team of Sadgaon Police Station staff, accompanied with Crime Branch Guwahati City Commissionerate, conducted search and raid in the rented house of owner Srimati Ila Kumar, wife of late so-and-so, house number so-and-so, Baguli, Panjabari near Ganesh Mandir, where residing the below noted accused person since 8 months and continuing illegal drug business over the greater Guwahati for their personal benefits. Accordingly, house has been searched in presence of local public and recovered and seized 23 packets suspected to be brown sugar covered by plastic soap, I think it should be soap boxes, net weight 302 grams, 20,000 rupees cash, and 2 numbers of mobile handset from the possession of accused person, which has been seized in presence of witness as per seizure list. During interrogation, it is learned that another more persons also involved in the illegal contraband drugs peddling. So I request you kindly register a case against the below noted. One is Hatneling Cookie murder, and the second one is Lalhoten Mangte, who has the second one has been granted bail. And my lord, if you go,
Who is the seizure witnesses?
my lord, the seizure witnesses are the PWT, my lord, Dipjyoti Ingti, the complainant, the SI. This is at page 48, my lord. On 5/6 so-and-so, I was posted as SI at Sadgaon PS. On that day, at about 7:30 p.m., OC Sadgaon, namely Inspector so-and-so, received a secret information to the effect that at Panjabari Baguli near Ganesh Mandir, one lady and one male person of Dimapur, Nagaland, carrying on illegal drugs business in the entire area of Panjabari by staying as tenants in the house of Srimati Ila Kumari, so-and-so.
Now, who is the and other witnesses, other independent witnesses?
My lord, the
Or-
other
That's
independent witnesses, my lord. Neighbor, my lord, PW 8 at page 65,
Left
then
out.
PW 9, my lord, page 66, PW 10, page 67, and we can take also the landlady, my lord, at page 50. May I place the landlady first, my lord? PW landlady is
Who
PW
exhibited seizure list? You are Hunteling Cookie.
yes,
Untelling
landlady.
cookie.
You are the tenant,
Yeah.
admittedly. From your house that has been recovered.
If we read the landladies, my lord, it was not from, my lord, what happened?
It
if
was from the house which was rented out to him. Landlady had identified this is your house.
My lord, it was sublet, my lord. That is what the landlady has said, and it has come on in the other witness, other evidence also. Page 50, my lord. That I'll clear off, my lord. My lord, may I take it to the relevant portion or I'll read it, my lord? My lord, I will show, my lord. I'll satisfy that I am also entitled to bail. If I may just take the relevant portion, my lord, at page 51, or I may read it, my lord. I am a resident of so-and-so. In the year 2021, Hatneling Cookie used to stay in my house as my tenant. At the time of taking my house on rent, there were two girls with Hatneling Cookie, and she told me that those two girls were her daughters. But later on, I could know that they were not her daughters. She also told me that she was serving in the Nagaland police. After about 1.5 months, many people started to visit Hatneling Cookie. That if so many people visiting her, I will not be able to allow her to be my tenant further. She told me she was searching for alternative house, and in that way, several months passed. One day, one evening, when I went to the terrace of my building, one daughter of my another tenant came running to me and told me that some police personnel had come to my house. Then I came to ground floor and introduced myself to the police as the owner of the house. Police personnel entered the tenanted house of Hatneling Cookie and recovered drugs. Around 15 days, this is important. Around 15 days before police searched the tenanted house of the accused, another person came to the tenanted house of that accused and started living with her. That is that Mangte, my lord.
Mr. Goswami,
Accused-
who are your projected seizure witnesses?
My lord. From the record.
Ah.
Because at this stage, my lord, Lordship may kindly see
You
the
see,
primary. at
see
least prima
if
facie
your
evidence.
landlord is, if landlord is your projected seizure witness, her evidence has been destroyed by the cross-examination.
No.
Is it can there be a possession like this? She is a seizure witness. I do not know from whom offensive such a recover. I do not even see the police waiting the offensive substance.
In cross, my lord,
Police did not.
other witnesses also in cross.
What other witnesses tell
There
us?
also, my lord, Lordship may kindly see the cross. My lord.
No, no. Why cross provision of cross is? So that it can demolish your prosecution case is demolished prima facie.
But
Prima facie.
at this stage, my lord, I pray, my lord, that the 11 witnesses already examined. So,
Hmm.
just prima facie, my lord. That
But 11 witnesses examined on last August.
because, my lord, she is, my lord, on treatment, my lord.
Not
She-
because of that, my lord. I
Because
came
she has to be
Madam,
there.
please, why?
sorry.
We do not like this.
Sorry,
I'm
sorry.
interacting. We
extremely
are not
sorry.
asking you.
I'm
But
extremely
she has to be there in the trial, my lord, because she was allowed to go for treatment, my lord. And also a second aspect, my lord, whether she is after 2 months, whether she has surrendered or not, that is not clear.
No, that is that there are some interim orders. That is continuing.
Yes, my lord.
So that's why we
So
thought we'll.
yes, my lord. If she participates in the trial, my lord, then other witness should be examined, my lord, and because it is the flagrant of the trial, my lord.
No, she is participating. She has not fled away, even
Yeah.
if our
Because she is
interim.
under treatment, my lord. And thirdly, my lord, the other accused, my lord, who the granted bail, my lord, he jumped out of bail, my lord, NBW has been issued against him. My lord. There is an order to that effect. So all these aspects combined, my lord, then the trial is hampering. My lord. If, my lord, perhaps they have a good case, but let it be, my lord, will logically end, my lord.
Pathetic, Mr. Goswami. Have you seen the forensic, everything.
Yeah.
What will you gain? Who is to be examined now?
কোন আছে আৰু ৰেকৰ্ড কোন আছে আৰু কোন
Scientific officer. Forensic or none.
Yes, my official witnesses are left, my lord. It can be my lord concluded. 7, 6, 11, 9, 6, I have received this. I was.
Who is the IO? IO is PW 6.
My lord, PW 14,
Hmm? PW
14,
page,
page 31,
page.
31, my lord. 31. What page 31?
No, no, has he been examined?
14, 14. My lord, only this, in the list of witnesses, my lord, this 14 and, uh, and this 9, 10, my lord.
Uh-huh.
Page 31 at serial number 14. And at page 30, my lord, serial number 9 and 10. And in fact, in the evidence, my lord, it has also come out, my lord, that the contraband goods were recovered from the room of the male person, my lord.
Who is PW 10?
He's from the SI from the crime branch, my lord.
What was his designation? Who is the informant?
The informant, this PWC, my lord, he is also SI, my lord.
Information is also not recorded.
Because
Have you seen?
I have gone through the evidence, so I am not now harping on the evidences part, my lord. I just,
This is the
Yeah.
37, this
Yeah.
is we'll have to see.
yeah,
Guwahati police situation where really, have you seen? All the officers will pass orders.
no. My objection under section 37. my dear court.
I'm grateful.
Don't object. We'll have and record everything.
No, because I have the.
Yes, we'll pass
As
this
per
order.
section 37.
We'll go through it.
No. Because this might have some bearing on the trial, that is why my.
That's
as
why.
Joshi may not,
We'll
Go to
not
the-
go to also such details.
yes, my, only because that would have, perhaps my lord, would have a bearing on the.
This is
trial.
not the way. Yes, item number. And what judgment you want to show?
One judgment, my lord, that if and when an application is pending
Hmm.
and the accused after have not availed that right, my lord,
Hmm.
then my lord, cognizance can be taken and further investigation can be, my lord, allowed, my lord. That is what.
This is in the same case or different case?
Oh, that you'll also be already passed judgment earlier.
No,
Case
that
36.
that
The same case, exactly same date, everything same,
same case.
same case, same.
Which judgment?
Para 77,
Out of the same police station case.
Same position, same case.
Para?
para 77, last page, lord, see, last.
I think we have dealt with this.
This is not
Para 7.
77. Equally respect, my lord, suppose a right has been accused, my lord, but he has not availed of my. but
No, that's not here.
we didn't-
Do you say that he has not applied?
Not applied, my lord, and we didn't, then the extension prayers had come, my lord.
Applied when?
My lord, we apply on,
Yes.
Applied when?
Applied, my lord, after the, my lord, after 180 days, my lord. He has applied for,
Okay, so according to you, it was
Yes.
not pending on that day.
not pending on them.
Okay.
yes.
Huh? Pending assembly.
Oh,
Is he pending assembly? Huh?
see.
Assembly.
That we know, that we have recorded already.
Yeah.
Please give the facts of this case.
My lord, the petitioner, my lord, this, there are 7 petitioners before Orsi Myers.
Arrested on,
11/9/2023.
arrested on
11/9/2023.
2023. Page forwarding,
Forwarding, my lord, you'll also find forwarding page 18.
page 88. Then
Tell my lord, the statutory period to complete the investigation was over on 8/3/2024.
statutory period,
8/3/2024.
832024. Now, when did you file the,
Admitted position there. Till 8/3 no charge sheet was filed.
okay,
Then on 11/3/2024, we filed an application seeking my default bail.
so you sought a default bail.
On 11/3/2024.
So on that day, there is no charge sheet.
No charge sheet, my charge sheet was filed on 29/3.
And when this extension was sought,
On same day, 11/3/2024. On that day itself, that application was disposed of, granting time to the my lord, investigating officer to complete the investigation.
and what about 11-3 default bail application?
They dismiss. The page 22 order,
Page
22,
22.
my lord.
And the application, default bail application,
Well, that we have not annexed, my lord, that is reflected in the order itself.
okay. And what is the application for extension?
Page 12,
Huh?
yes,
Page?
page 24, my lord,
Page 24. And dismissal order is page 22.
page 22, my lord.
Okay. According to you, since on
Yeah,
on
Since my here.
11-3, according to when charge sheet was filed?
29/3,
29-3-2024.
my lord. This is after 200 days.
Page,
Page we have enforced, my lord.
It is after the extension.
just
sir.
and page,
Number of applications submitted, charge sheet. Kashin my lord, page 25.
Page
Start
25,
from page 25, my lord.
page 25.
No,
And your lordship order, page 36.
So according to Mr. Goswami, his argument we understand.
no.
Your argument is on 11/3/2020, on 11/3/2023.
Yes.
There was a application pending. So according to you, application ought to have been filed on
Earlier,
8/3 or prior.
prior,
This is your case.
yes,
Okay. We'll pass this order.
no.
Maybe tomorrow or day after tomorrow.
All right.
25.
It was, no?
May I please?
Yes.
Judgment is still.
Population. Criminal appeal. Little.
Pursuant to this court's order dated 24/6/2024, an affidavit has been filed by the Sub-Inspector UB, Nayanjyoti Deka, and he is also represented by Mr. Learned Counsel, full stop. Though the bail was granted to the petitioner, however, taking note of the fact that during currency of an interim order of bail, the petitioner was arrested. This court has issued notice to the aforesaid police officer. Full stop. Officer, full stop. Therefore, this court also of the view that this is an important issue in as much as during the currency of an interim protection granted by High Court and in the alleged backdrop that it was intimated to the said officer, the petitioner was arrested and was produced before the court. Full stop. Accordingly, this court has requested Mr. N.J. Datta, Learned Counsel, to assist this court in this matter. List this matter on so and so, will give a date, registry to furnish a copy of this copy of the record to Mr. Datta.
Done. Some judgments are there, where there is some confusions arise, my lord, that whether they can arise if violation of interim conditions, my lord. Some interpretations are there, but ultimately, my lord, that the court said that there should not.
Ultimately is the arrogance.
Yes.
Ultimately is the arrogance.
My lord, that some restraint should be there, that is. But the confusion arose, that is and been interpreted, my lord.
Let us see.
Yes.
That's
because
why you have
Yes,
we want to have an
because
independent
plain reading, my lord.
we want to have an
Subject
independent
to correction, my lord.
we
Plain
do not
reading.
want assistance of
Yes.
the petitioner because
Yes.
he will have his own view.
Yes, yes,
He will have his own view.
Yes.
You are an additional party. Let us
Yes.
have a third party
yes.
who will just assist us, not
Yes.
against anyone.
That.
We'll give a date later on. Yes.
So. Obliged.
This is case,
Into
eh?
arbitration. This could be disposed of, my lord. Other petition bail is pending, no?
Which one?
Meenakshi, my lord.
Next
Next.
bill, next bill application, along with these two petitioners
Yes.
are there. Huh? This is disposed of, I think.
Disposed, I think.
Huh?
This is not disposed. She has appeared.
No, this is DA, BA,
AB, my lord.
AB, 1339.
123.
Full stop. Case diary is produced, given application of so and so. Case diary is there.
Yes, yes, yes.
The petitioner has cooperated, so and so. peruse the materials available on record. This court, after perusal of the same, this court is of the opinion that custodial interrogation of the petitioner may not be necessary inasmuch as the petitioner has cooperated with the investigation. Accordingly, presence allowed. Interim order absolute.
Mr. Abhay.
1728.
Yes, sir.
May I please, Lord? My lord, item number 27, my lord. My
Hmm.
learned pen has filed vocalogram. I do not know. It is very surprised, my lord. Yesterday I have talked with my client, my lord. My lord,
Who is, you are, yes,
The petitioner when with the file petition, he has returned the
no, my lord.
petition copy.
My lord,
Sign in the appellate, my lordship.
no.
This is
Oh.
the petition.
My lord, I have talked yesterday, my lord.
we are sending you the, both of you to the bar. Who filed initially? Have you taken any no objection from this lawyer?
Contrary to
There is a
the High Court
dispute
rule,
who in the bar, who will represent the petitioner. That is whether Mr.
my lord,
Whether Mr.
A Manna.
A. Mannav or E. Ahmed. In view of the aforesaid, this method
My lord,
is
I have-
adjourned.
I have moved the case, my lord, for 5 days, my lord. 5 days, today is the fifth day. My lord, no instruction from my client for Uddain. My lord,
File an application to withdraw the brief. We are not here to decide who is have this brief. Please, don't bring all this to this court.
my lord,
Follow proper procedure.
my lord, exactly, my lord.
If exactly where you are saying that you are no instruction and all.
My lord, Item,
Yes.
item number 28, my lord. My lord,
Yes.
This is the second time, my lord. Here in this case, my lord, 2 petitioner, my lord.
And here I have to, submission is done. They were surrendered, and they were produced before the.
One is surrender, my lord. And
They are
present
surrendered.
petitioner, item, present, petitioner number 2, Eliza Khatun, my lord. He is, my lord, the college going student, my lord. My lord, he is a fifth.
Do you know how she has beaten us, this old man?
No, my lord, my lord, my lord,
Eliza Begum.
Yes.
my lord,
Materials
Eliza,
are there.
Isn't it? I
Yes.
have seen that case.
Materials
Still I
are there.
recall the case diary.
Yes.
Near the pond.
Yes.
Isn't
near the
it?
phone, madam.
I
Very-
still recall how you had beaten up this old man and how he fell down. Thereafter also, you people beat him. Specifically, eyewitnesses taken your name.
my lord,
Without going through the
Yes.
CD, I am telling you.
yes, my lord, one
Lordship,
line
remember,
submission, my lord,
yes.
before your lordship, one line submission, my lord. All the accused persons surrendered, except this,
You also surrender.
except this, my lord.
You
See, this is college going student.
Maybe we are not.
My lord, only thing, my
College going students should behave like college going student. That's all. A person died.
my lord, dispute, my lord, with a pond, my lord, in between brothers.
We do
And
not
their
know
sibling.
what the eyewitness. We are not here to comment on anything. What eyewitnesses says that you are one of the person who beat up this old man who fell down near the pond, and thereafter also you have beaten them up. Is that it, Mr.
Yes,
Goswami?
Yes, madam.
Exactly the same.
Materials are there, madam.
When we passed this order, I still recall this.
Petitioner number 1, madam, surrendered, madam. So here on the-
My lord, your lordship kindly see as many as eight
Dismissed.
accused, my lord, 7 accused, my lord, all
Dismissed.
surrendered.
The second is, you also surrender.
My lord, only
Item
my
number?
humble submission before lordship, he is a student, my lord. My lord,
Item-
fifth, BA fifth semester student, my lord. That, my
Maybe.
lord, may be
DSP
considered.
minister should not do all these things. Person has died. Pay item number
Last order is of, madam, page 32.
28, dismissed.
Page 32 is the last order.
Yes.
Seven.
7 you resolve, then we will take up. Not now. Yes.
Right.
Take some time, no? Mr. Bhattad, you are going for final disposal. I know it. Main writ petition.
Your lordship will kindly see.
the entire property mentioned here is the subject matter of a trial which is going on. So your lordship may kindly come to page 68.
Yes, 68. Yes.
Annexure 14.
Mm.
Above named complaint file a complaint under subsection 5 of section 5 of the Prevention of Money Laundering Act against you. You are called upon to indicate the source of your income, earning or assets out of which or by means of which you have acquired property attached under subsection 1 of section 5 of the Prevention of Money Laundering Act. The evidence on which you rely and other relevant information particular and so cause why all any of such property should not be declared to the property involved in laundering and consequently why the attachment order should not be confirmed. My grievance is that only.
So they are not sure whether it is a
No,
tinted money. Yes, or
My lord,
what is the procedure?
my senior,
No, just you are asking it. Yes.
My lord, we will go by section 6 and section 8 of the
Okay,
PLMA
okay.
Act, my lord.
Okay, what's primary? These are the initial things we'll go in depth. It seems that you are not sure whether it is tainted money or not.
moreover,
My lord, will understand one thing, my lord, the Supreme Court in my lord, Vijay Madan Lal has categorically, my lord, distinguished PLMA and section 8.
Hmm.
Criminal proceeding and civil proceeding. This is,
Okay,
section 8 is a civil proceeding, my lord, not a criminal proceeding, my lord.
okay,
Supreme Court has, my lord, categorically distinguished.
okay. Thick, okay.
now if I disclose at this thing,
Hmm.
they will not investigate the matter. Only on basis of this, they will proceed. But how? Why should I disclose at this stage? I have cross-examined the witnesses. Let them take the certified copy. Let them know what is there. Entire property
Yes.
mentioned in the CBI case number.
Where is the, this is in a, under section
Right.
5 and 5 filed by, against you. Yes,
Entire money is not in my possession. Is in the court.
Is by SC.
Seized by the anti-corruption department.
so your property is under attachment.
Seized, they have seized in connection with that criminal case.
Yes, okay.
So this is not with me. The money which was seized, that was kept in the,
Let us understand the facts first, how it was initiated, when CBI case was filed.
page 21 annexure 1.
Page
21 annexure 1. Complaint by a private person, contractor. May I read it, madam? With due respect, I would like to inform you that I am a contractor by profession and I approach the authority to release the fixation of selling. But it is very unfortunate to inform you that 27th March 11:30, the irrigation department dispute, Sekushendra Dalwai demanded bribe 3% of the total ceiling amount to issue the ceiling. On the other hand, FAO, the department also demanded bribe rupees 10,000 for the ceiling. That 3% of the ceiling amount, rupees so and so, I am to pay this huge amount against the pending bill, amounting to rupees so and so only. And I am not totally willing to pay any bribe to the above officer to release the ceiling. I therefore request you to kindly take the legal action against the above noted conduct. So this anti-corruption department has registered the case, madam.
Lecture, yes, serial is gonna say.
Page 25,
Hmm.
this is a list.
Okay. Page 12, just a minute. Yes.
Originally is next page, page 26.
Hmm. So it's a trap case basically.
Yep.
Trap case. Okay, then how ED initiated this PMLA?
I do not know, my lord, on that. That is the atmosphere in the entire country.
My lord, that is the law.
No, Mr. Where is the in
Your lordship, I am asking for.
what is the how PMLA was initiated by which document?
Seven zero.
70, page 70. Complaint before the
Page
70.
70.
Next 11 to amounts to permission to apply on the statement of approval.
Who is representing this PMLA authorities?
My lord.
Permission was here. Must statement of approval. You could apply statement of approval.
Page 50.
So there is an provisional attachment.
A statement was recorded,
Hmm.
my statement,
Hmm.
under section 50.
Hmm.
And then, my lord, 56,
Is the order of from the court.
they took the permission of the court.
To interrogate you in the custody.
Next, 56.
56.
Page 56.
Then a summon was issued to me.
Okay. Now thereafter, they lodged this complaint
Yes.
and attachment order.
Page 58 is commissioner.
And excerpt 12.
Page 58.
Commissioner.
Entirely subject matter of the anti-corruption amendment case.
64 talks, right? It was talks, basically, 64, right? This conclusion is got to be to the PDF. আমার লোক থাকবে
Paragraph 13.
Your Lordship may kindly come.
This is the provisional attachment.
Yes. Kindly come to page 64,
64.
last paragraph.
Yes.
As the above are proceeds of crime in terms of section 2 of PML 2002, generated directly as a result of the criminal activities and indulge in the activities of money laundering terms of section 3 of the seized money is at so and so as discussed above are with ACB, anti-corruption, which has filed a charge sheet numbered as so and so in the special court Guwahati, reserving the provision for filing supplementary charge sheet. The above movable properties seized by the ACB being proceeds of crime as subject to the adjudication and confiscation under provisions of so and so, I have reason to believe that the above 8 movable properties are likely to be concealed, transferred, or dealt with such a manner. But if no provisional
But
attachment,
this has already been seized.
I do not know what they want.
I could correct the idea. I could
My-
say any.
I will make my lord understand.
No, definitely will make. We are not understanding.
My lord. That
we-
is the law,
we-
my lord.
huh?
That is how it proceeds. PLMA, my lord.
No, PMLA may proceed. Law is there, we know that.
My lord.
But we want to understand.
My lord. Attachment, my lord, this is symbolic, my lord. We don't confiscate the property, my lord. This will be attached for,
Understand.
my lord.
What is the purpose of attachment?
Purpose is, my lord,
What is the purpose of attachment in PMLA? Let us know, understand.
purpose of attachment so that, my lord, money doesn't, that property doesn't fall in the wrong hand, my lord. So that's why symbolically we, my lord, the central government under the act, my lord. That is the law, my lord. So, my lord, that is the law,
We are asking Mr. Dhar,
my lord.
what is the object of provisional attachment? Let
Provision-
us understand.
My
What is the object of provisional attachment under the act?
lord.
We cannot go beyond law. We know that.
Fine.
But we want to know, we know nothing. You may know, we know
no,
nothing.
no,
We
no,
want
my
to
lord.
understand what is the object of provisional attachment.
My lord.
Let us read it.
My lord. My lord will, PLMA act, my lord.
Yes, read it, We'll go
My lord.
section, tell us, we'll go.
Section 5, my lord.
Section
Attack-
5.
Attachment of property involved in money laundering, my lord.
Okay.
Where the director or any other officer not below the rank of deputy director authorized by the director
Hmm.
for the purpose of this section
Hmm.
has a reason to believe,
Hmm.
my lord, reason to believe,
Reason to believe. Okay.
believe, the reason for such belief to be recorded in writing
Hmm.
on the basis of material in possession that
That.
any person is in possession of any proceeds of crime.
Hmm.
And such proceeds of crime are likely to be concealed, transferred, or dealt with any manner which may result in frustrating any proceeding relating to the confiscation of such proceeds of crime under this chapter, my lord.
Okay. So what are the conditions?
My lord,
Just once again, read once again. What
Yes,
are
my
the
lord.
conditions?
such proceeds of crime are likely to be concealed.
Conceal. Who will conceal? Where you, how can you have a satisfaction that when the money is in a, it's not a immovable property, it's a movable property. Its movable property has been seized. Who will conceal it?
My lord,
And who will use
My
it
lord,
for its
we-
terrorist activities?
we are not only on that. PLMA, my lord, we are now investigating, my lord.
No, we'll come to that
We
later on.
we are not only on this, what has been seized.
No,
We
Mr.
are on
No,
more.
You may be on many things. We are not concerned with. We just answer this question and come to page 65. What is the schedule of property that you have attached?
My lord, 65. Yes, my
You
lord.
must have a satisfaction and reason to believe
My lord.
that this property is an tainted money, meaning thereby that this money has been acquired for proper wrong or it's a proceeds of crime.
My lord.
Number one,
My lord.
and it is not or, and that this money is likely, if not attached, then it will go away from your hand. So these are the two objects. Therefore, it is provision because this is a stringent provision.
My lord.
A person's property can be attached
Attest.
because they have a belief that if we do not do it, then it may go out of our hand. So therefore, the object of provisional attachment and that too for a specific period. So that
6
it,
months.
huh?
6 months, my lord. We can only attach it for 6 months.
6 months. So why this? What is the object?
Now I'm coming there, my lord. Let
So
me
let us first understand then how money already says then under custody of the investigating authority or under custody of the court they have an apprehension that this money will go out of the hand.
My lord, let me continue, my lord.
Yes, no. Therefore, first line. Once again, read once again. When can you do provisional attachment? First, let us satisfy that. Then we'll go to the other proceeding.
Such proceeds of crime are likely to be concealed,
Hmm.
transferred, and dealt with any manner
Hmm.
which may result in frustrating any proceeding relating to the confiscation of such proceeds of crime under this chapter. My lord, we are talking about only PLMA, my lord. And this is a special provision, my lord, 71 of this act, my lord. It says that it will override all other, my lord.
Oh, we understand. It accept it. It overrides everything. But to exercise your power, the legislators and the Parliament in its wisdom had given you a condition that yes, you can do this. Everything is overridden. But these are the condition you can do it. So therefore you say us that these are available in this present case. We are not questioning your power right now. We may question, but not right now.
Now, I'm going further, my lord.
Yes, go further.
Provided that
Hmm.
no such order of attachment shall be made unless in relation to the scheduled offences. So, my lord, these are scheduled offences.
Okay.
Scheduled offences, a report has been forwarded to a magistrate under section 173 of CRPC, or a complaint has been filed by a person authorized to investigate offence mentioned in that schedule before a magistrate or the court for taking cognizance of the scheduled offences, as the case may be, or a similar report of or complaint has been made or filed under the corresponding law of any other country, my lord.
Yes.
So that is not there, my lord. So basically, my lord,
Basically, provisional to our limited understanding and knowledge,
my lord,
these are very stringent provision
my lord,
by which an authority, an investigating authority is given a power to attach property even provisionally.
provisionally 60 days.
Even provisionally.
6 months.
So therefore, the legislature in wisdom has said it cannot be beyond 6 months and subject to having satisfaction of these two criteria.
Now, my lord, now the thing is that my lord will take up section.
No,
6.
let us first understand this section.
Here I am coming, my lord. Why?
No, so according to you, these two conditions are fulfilled here.
Fulfilled. And
How? Let us understand.
and no, my lord, I am on, my lord. This court has not jurisdiction, my lord, to take this matter up, my lord.
Why?
Because-
No jurisdiction 226 court?
Yes, that is
Under what provision?
That is what my lord, the act says. And Supreme Court has laid down, my lord, That is what where I'm, my lord.
Okay. If you are questioning the power of 226 by virtue of PMLA, let us understand this.
My lord, when there is alternate remedy by statute,
Hmm.
that they have to address this before that authority. Then there is an appellate authority.
I
And
suppose,
then, my lord,
I suppose, Mr. Dhar, you are properly prepared today.
I am prepared, my lord.
Okay, fine, proceed.
My lord. My lord, I'm just placing why this appellate thing I'm coming, my lord. To start with, my lord, I will come to Vijay Madan Lal last, my lord. This is the case, my lord. It's a long, old case. From there it starts, my lord.
Hmm.
My lord, here is the case.
Hmm.
It refers to one of our Assam's case also from Dhubri. My lord will come to para 34. My lord,
Hmm.
page number 8.
Okay, say the ratio.
Ratio, my
See,
lord.
because see, our limited knowledge shows that well settled principle of law that the 226 power of 226 is a basic structure of constitution.
That is what, my lord.
Power of judicial review is the basic structure of the constitution, and this power cannot be fettered by any of the power. And the 226 power not to entertain a writ petition for having alternative remedy is a self-restraint. There is no rule as such. It's a self-restraint upon our court with a laid down parameters.
My lord, may I read, my lord?
Listen,
My lord.
and you have minded, you have made a submission that this court has no jurisdiction.
My lord, that is what Supreme Court
Yes.
said, not my words, my lord.
Yes.
This is what Supreme Court said, my
Yes,
lord.
yes.
I'm just reading what has fallen from this,
Yes.
my lord,
Yes.
apex court, my lord.
Yes.
That is what I'm reading. This is not my words, my lord.
Mm.
I'm reading para 34, my lord.
Mm.
When a statutory forum is created by law
Mm.
for redressal of grievances and that too in a fiscal statute,
Mm.
a writ petition should not be entertained, ignoring the statutory dispensation.
Mm.
In this case, High Court is a statutory forum of appeal of a question of law that should not be abdicated and given a go-by litigant for invoking a forum of judicial review
Mm.
of the High Court under writ jurisdiction.
Mm.
The High Court, with great respect, fell into the manifest error by not appreciating the aspect of the matter.
Mm.
Then, my lord, I'm coming to para 36, my lord.
Mm.
Reference may be made to a constitution bench decision of this court, rendering in Than Singh, Natmal, and others versus the Supreme Court of Texas, Dhubri,
Mm.
Assam, reported in AIR 1964 SC 1419,
Mm.
which was also a decision of a fiscal law. Commenting on the exercise of wide jurisdiction of High Court under Article 226, subject of self-imposed limitation.
Ah.
This
There,
court went.
this is
the-
the constitution bench. That
this-
is what I am referring.
This is what my lord, the
Ah.
honorable apex court said.
No, Mr. Dhar, while arguing, you will have to mind your language.
My lord,
See, why I am saying is
my
that
lord.
it's very dangerous to say that 226 court power is ousted.
No, my lord.
So read that.
This is what I'm reading.
What Natmal says.
My lord, the High Court does not therefore act as a court of appeal against the decision of a court or tribunal
Yes.
to correct errors or fact,
Mm.
and does not, by assuming jurisdiction under Article 226, trench upon an alternate remedy provided by statute
Mm.
for obtaining relief,
Mm.
where it is open to the aggrieved petitioner to move another tribunal
Mm.
or even itself in another jurisdiction for obtaining redress in the manner provided by a statute. The High Court normally will not permit
Normally.
entertaining a petition under Article 226 of the Constitution, the machinery created under the statute, to be bypassed,
Mm.
and will leave the party applying to seek restored to a machinery to set up. My lord, my thing is that maybe I'm wrong. My lord, yes, my placing of words were, my lord,
That is very important for a
very
lawyer.
incorrect, my lord. I apologize for that, my lord.
That is very important in a courts of law.
I
You may
I
say that
apologize,
this is a case which is not fit for exercise of jurisdiction
No, no,
under
no,
Article
that is
226,
actually
having an alternative remedy.
That-
Can you say this court is not having jurisdiction?
my lord,
226
yes,
court.
I was, my lord. to
That's
the,
why we have reacted.
I am sorry, my lord.
No,
My
that is fine.
placing of word was wrong, my lord.
Very important. Placing of
Yes.
word by lawyer is very important.
I am
Yes,
sorry, my lord.
proceed.
But my lord,
Hmm.
this
You
is,
may say that this is
this
a
is-
case, this is the order,
this is, my
if
lord,
this is an alternative remedy, this is efficacious, so this court should not, may not exercise its extraordinary jurisdiction.
exactly,
But
my
to
lord.
say
Yes.
that this court will not, power under 226 is taken away by PMLA,
No, not by PMLA, my lord. My lord, ordinarily, my lord, when there is an alternate remedy, my lord, that is what the.
this is ordinarily. There are
Yes.
3-4 criteria where they are laid down.
Yes.
Now, recently, that judgment, I forgotten, I relied on a judgment on last, that even a new ground has been added there too.
My lord. My lord, now I can place my lord's similar issue. My lord has passed an order.
No, we passed this order.
My lord, that judgment is here.
Therefore, Mr. Thor, let us understand the facts. We are not, we are aware of the proposition of law that
Now,
generally, when alternative remedy is available, this court will not exercise, will decline to exercise its jurisdiction, even after having such jurisdiction.
my lord,
Especially in exceptions are when without jurisdiction, principles of natural justice is violated, fundamental right is violated.
my lord,
Now his whole argument is my fundamental right is violated.
my lord. Now, my lord, this section 8, my lord,
Mm.
that Supreme Court has, my lord, distinguished, my lord,
Mm.
two aspects.
Mm.
Criminal and, my lord, I have marked this in orange flag, that part, my lord, in Vijay Madan Lal. It's a latest judgment, my lord,
Mm.
by the Honorable Supreme Court. It's a constitutional bench,
Not
my lord.
latest. This was
23, my lord, but this is
2022.
23, my lord.
Reported in 23 might be,
Ah.
2022. And this has been interpreted recently,
Yes.
once again.
Yes, my lord. So, my
And
lord,
review is pending.
review is pending, but,
Yes,
but
that
that
has
that
been
is,
interpreted in different way.
yes, but this is the law, my lord.
This is the law, but with the interpretation subsequent, if Supreme Court deals with this and gives some interpretation, that will be binding upon us. Is that it?
Exactly, my lord. That is. So, my lord, now I'm coming to what this Honorable Supreme Court has, my lord, how distinguished, my lord, this section 8.
What is the foundation of your section 8?
Section 8,
That
my
is
lord,
very
is,
vital. Foundation of your section 8.
section 8 is the, my lord, is an section is the executing authority appointed under section 6, my lord. He is an authority, my lord, for any attachment for confirmation. We have, he's a neutral party. It's not from PPLA, my lord. We are also, if we are aggrieved by the order of the executing authority, we will go for an appeal in the tribunal. If they are aggrieved, they will go tribunal. And then, my lord, will come back to, if tribunal also turns down,
We know that,
either
we know that.
will come back to
High
the
Court.
High Court. So, my lord, now, my lord, I'm coming back to para 161, my lord. I have marked with blue flag, my lord.
Okay.
In para 161, my lord, that blue flag, maybe it's in the left hand side, my lord.
Hmm.
The Delhi High Court has had occasion to examine the provision of Article 2002 Act in Vakamula Chandrasekhar Supra and noted the special features of Act which deals with both civil and criminal consequences of as against the offender. Having so noted, the High Court observed following. The Act of Money Laundering has both civil and criminal consequences for the perpetrators. To deal with civil consequences, the Act creates and empowers the executing authority under section 2(1) and read with section 6 with the power of civil court to summon direct production of documents, evidence, section 11, and adjudicate on the issue whether any property is involved in money laundering. That is section 8, my lord. It also creates the right to appeal from orders of executing authority, section 26, and designate appellate authority authorized to hear appeals. That is section 2B, which reads with section 25. It also creates the right to further appeal before the High Court, section 42. That is what my just I submitted, my lord. Then the next para, my lord. It is thus clear that power invested in the officials is one for conducting inquiry into the matter relevant for ascertaining existence of proceeds of crime. and involvement of person in the process or activity connected therewith, so as to initiate appropriate action against such person, including seizure, attachment, and confiscation of the property, eventually vesting in the central government.
Hmm.
So, my lord, basically my case is, my lord, whatever it is, my lord, that's under section 8, there is an authority, notices come from them. He is, my lord, we are not part of that. That is a court, my lord. Even if we are aggrieved by that notice, my lord, by their findings, by the order, my lord, we will also go for an appeal,
No,
Yeah.
that I understand.
my lord. So, my lord, my thing is that at this juncture, my lord, they have to go there, my lord. We even will go. The authority will pass an order, my lord, either way, my lord. It will go for an
Now
appeal,
let us read section 8.
my lord, section 8, my lord. My lord will come to that orange flag, my lord. Supreme Court has very nicely dealt with section 8. That orange flag, my lord.
Section 8.
My lord.
Hmm.
It is there, my lord, section 8. That orange flag, my lord. My lord, what is, my lord? The section is a part of chapter 3 dealing with attachment, adjudication, and confiscation. It provides for the procedure and safeguard to adhere to the authorities referred in section 48, and in particular, the adjudicating authority appointed by the central government under section 6 for dealing with the complaint filed by the authorities officers under section 55 of the 2002 Act, or applications under section 17(4), 18(10), and such. This is a wholesome provision, not only protecting the interests of the person concerned, but affording him her fair opportunity during executing process. This is, my lord, what Supreme Court says, my lord. That is a very fair, transparent, my lord, authority, where everybody will get a fair chance of hearing, my lord. That is very important, my lord. My lord, the adjudicating authority is not a part of our this ED's, my lord, administrative setup, my lord. That is what, my lord, Supreme Court says, my lord. Further down below, second last paragraph, if I read, my lord, provided that if the property is claimed by the person other than person whom the notice has been issued, such person shall be given an opportunity of being heard to prove that property is not involved in money laundering. So that is, there is provision, my lord. He will get a fair chance to, my lord, to prove that this is not involved in money laundering or it's not a procedural crime. It is not that, my lord, it will be attached. For 6 months, my lord, it will be within the, my lord,
Hmm?
domain, my lord. That is 6 months by the act, my lord. Provisional attachment. And, my lord, the authority will, within 6 months, they will pass an order, my lord, either way. They will even let it go free. It has happened many times.
This power can be exercised subject to what you say. Apparently, if you read,
My lord.
when properties are attached, and
My lord.
properties are attached, because till properties are attached, it is not established that it's a procedure of crime,
Yes.
is not it?
Yes.
It is not established that it is a procedure of crime. In apprehension that this man is having so much of property, let us attach it,
Exactly.
is not it?
Exactly.
So, and attachment, two conditions. One is you have attached that you have reason to believe, and second is that this may go out of your hand, is not it?
Exactly.
So, in such conditions, you may attach a property provisionally for a
Provision.
specific period, thereafter final attachment, so on and so forth.
After this
Okay.
executive authority, my lord.
Now, since your source is not, you are not aware of the source and whether it's only you presume that this is a procedure of crime, you have reason to believe It is not established. You have reason to believe that this is a proceeds of crime. Therefore, you attach it. And therefore, the adjudicating authority has been given a power to ask the person accused, saying that, yes, these are attached, please show us. What is your source? What is your source? He may come and say that, no, this is not proceeds of crime. This is the property gifted by my father. This is an
Yes,
inheritance.
from any legal means.
Legal means this is not proceeding. Thereafter, the adjudicating authority will decide. Now, in the case in hand, what he need to explain? It is your case that this is attached and it is a trap money, movable property money, this amount of 3 lakhs, 2 lakhs, 10 lakhs. That has already been attached. What he required to explain?
My lord,
There is total non-application of mine by the adjudicating authority.
my lord, adjudicating authority hasn't taken up the matter as
So
of now.
adjudicative authority will issue the condition precedent for calling upon, if we go to section 8, to indicate the source of his income, earning or asset, out of which or by means of which he has acquired the property attached. Your case is that we have caught him red-handed. Everything is known to you. You have written in your complaint. What more you require? What will he explain? This is total non-application of mine to the given facts of the present case. Do you get my point?
But
Had it been a case that along with this money, you have attached his flats at so-and-so, houses at Delhi so-and-so, this, his wife's property, everything you have attached, then it will ask, adjudicating authority to ask, please show yourself. If adjudicating authority is satisfied that this is not tainted money, he may release it or it may approve the final. Here is a case, whole case is that we have caught him red-handed and 10 lakhs rupees are found. How can you ask his other properties? You have not attached. You can ask only for C. You can, he has acquired the property attached. Here you know what the property has been attached, acquired, how he has acquired. This is your admitted allegation.
not my lord, the adjudicating authority has written it.
Not by you. You are arguing that is by you.
No, my lord. My argument is that he has to go there.
Why should he go? Everything is before you.
My lord, unless he goes there,
No.
we have already provisionally attached.
You have provisionally attached. He
Now,
finally attached his property. He has no problem on that.
No, my lord. The thing is that
His whole question is
we-
in the backdrop that you
we-
know this is my property, you have attached. So you have attached. What is the meaning
we
of this?
we cannot, my lord, keep this attached more than 6 months.
You make it final. He is not interested.
We cannot, my lord, unless he goes there.
He will not go. You make it attached final. He will not go. Can you bound him to go to reply?
No problem, my lord.
You attach is finally you confiscate. It's up to you
My lord,
because you have attached some cash amount. And you want the source of that cash. You yourself have said my reason to believe that he has collected this money from so on and so forth. What is the object of section 18? Section 8. Some time to think over.
that is there, my lord. But my lord, the thing is that
No, if you proceed.
my lord is making my case more easier. Because if he doesn't go, and my lord just closes the case, I have no problem.
We'll say that this in the given facts of this case, this was not at all applicable. And so therefore he's exceeded his jurisdiction. Adjudicating exceeded his jurisdiction. And when it is excess of jurisdiction, we can very well interfere. See, Mr. Thor, you understand. If you want some time, think over it, just think over it. You read section 8. Therefore, we'll go to the Supreme Court judgment later on. Isn't it? Please read once again.
Section 8, my lord.
Section 8. Read one again. He may serve a notice. From that you read it. What adjudicating authority, let me read slowly.
My lord,
He may serve a notice of not less than 30 days, not relevant for us,
Hmm.
on such person. Who is the person here? This petitioner.
my lord,
Calling upon him to indicate the source of his income, earning or asset. Okay? Source of income, earning or asset, out of which or by means of which he has acquired the property attached, not other properties.
my lord,
He has acquired the properties under section 5.1. You have attached property under section 5.1, some cash amount from his chamber. You know it. In your complaint, you have said that so and so has done it, so and so does it. What is the necessity of this? You cannot ask for his other properties until and until you attach. If you attach his other properties, of course, you may say, because you do not know his source. Here you know the source. So and so has given him the money according to you, subject to however proof in the trial court.
okay, my lord, I will just seek one instructions. I got it.
Simple. It
Ah.
is a different case. It's not like other case that many properties are assessed. In earlier case, what happened? His bank account, his building, everything was attached.
No, my lord,
So therefore, we say that okay, you disclose what is your source of these assets. Here in this case, you have declared that this is the amount you have attached.
No.
This is his source of
No, my
source.
but the thing is that, my lord, we have already attached whatever the property, my lord.
Yes.
Now, my lord, what happens to that? Cause if,
What happens to that is not a subject matter
No.
of this case.
cause that is the subject matter, my lord.
Yes.
Why I'm coming there, my lord?
Yes.
Because unless that under section 8, the authority, my lord, confirms it, we have to let it go.
He is not interested in replying because you know, so you proceed as per your wish. Attach it, you confiscate it, whatever you want. This is not our subject matter.
We are, my lord, I will take instruction only on that, my lord. What they are interested in now, my lord.
Heard Mr. Bhattacharya at
My
some
lord,
length,
keep it part hard. We have- we have
at some learned senior counsel assisted by Mr. De. Oh, sorry, nobody is here. I am dictating. This is your case, I think, Mr. Bhattacharya.
Lord, basically, I have come against the notice
Notice.
because
Ah.
trial is there pending. You want me to disclose my source. At this stage, if I disclose my source, my defense will be prejudiced in a trial court. About 15 witnesses have been examined. And moreover, section 5.
Let us, if we go that way, that you do not want to disclose, can you say that suppose tomorrow, which provision you want to show? Suppose tomorrow, your other properties are attached. They want to know, the act has provided a provision that they can ask your source.
Let them ask.
You have,
that.
they have asked you.
No.
No, they by this notice.
Entire property seized
Hmm.
has become according to the proceeds of crime.
Ah.
Admitting, suppose I admit this is a proceeds of crime, then also I have to defend myself there.
No, yes, that's correct.
So that you cannot prevent me. Your lordship will say Article 20.
That you cannot give evidence against
Yes.
yourself. That is your
That
case.
is my case. I am not questioning his all those things. These arguments are not available to him at this stage. Because it is not only under their possession, it is the seized amount which is exhibited in the trial court, and we process, if they are so interested, they can take the certified copy of my cross-examination. But why should I? I will not. I don't know whether my learned friends are that much courageous. I will simply say one paragraph. No, I am not going to do it because my right under Article 21 will be violated. That's all. Rather, they are admitting thereby, you do not know how I have earned this money. And now what I have cross-examined.
That's correct.
So they can't stop it, not they. Not even a court can stop it. That's my fundamental right. Apart from Article 14 or 21. I have taken that ground. They have not read it, nor they have bothered to know about it.
But difficulty is that the provision of section 8, which empowers an adjudicating authority to ask you something which may go against you.
Let it go. I am presuming that it is against me.
No, just listen to me. The legislature, parliament has enacted an act, section 8, empowering an adjudicating authority to disclose certain thing which may have an effect of violation of Article 21. But such provision was upheld by Supreme Court. This was one of the argument. This was one of the argument. But that was upheld.
What is the facts of that case? Let us see that.
No, that we understand, but
Because,
principle.
yeah, whatever the anti-corruption department has done, on the basis of that you have done, you have not investigated anything. Now I am defending that case. I am not saying don't proceed. You proceed under
So
the amendment.
therefore, in a given facts, it will be difficult for a writ court to say that this because of violation of, this will violate, infringe your right. That may be in view of the Mandala case. In some paragraphs,
yes,
there
yes.
are specific that
Specific.
no, this will not violate this right under
That will
21
depend on the facts of the case.
facts of the case.
Because our
Anyway.
case is, somebody has investigated my case, you got that, you have not.
That's why I'm saying that this is your case, that this is the source, this is the thing you yourself allege. So if you again ask me to admit it,
Exactly.
then it will be a violation of Article 21, because you know yourself.
Will not include that.
You are further want to ascertain. You have your information, you proceed as per that. Why should I affirm in given facts of the
My
present?
respectful submission would be, will not you wait for some time. You see the result of the criminal case, there you will be able to say, if I am convicted,
You are
that will
confident.
be a proceeds of crime. In that case, they are not presuming. Your lordship,
That view is also somewhere diluted, isn't it? In some cases state that even that is Delhi High Court and some other states no.
says that, but
Uh, says that even if that is over, they can independently proceed. In some High Court, it says that no, when the fundamental foundation is gone, how can you proceed under ED? That
My
is
lord,
not.
yesterday one case came up before the Honorable Supreme Court, my lord. This Abhishek Banerjee and his wife, my lord, challenged the Calcutta High Court's decision, my lord, judgment, my lord. Supreme Court, while dismissing the case, my lord, that violation of Article 20 and 21, my lord. I just,
But these are oral remarks. Anything
No.
recorded?
no, this is a reportable, my lord. Yesterday's judgment, my lord. I just got a printout from
Give
the
us a copy.
website, my lord. It is yesterday's.
Mr. Bhattacharjee is submitting that this matter should be adjourned and wait till the trial. But you have filed an IA. That's why we have taken up this matter. Otherwise, you could have issued a rule and fixed it for hearing. But you have filed an somebody has filed an IA.
We, my lord,
where is the difficulty for me?
my lord. We have
In spite
difficulty,
of
my
the
lord.
fact that they can proceed with us.
So let you have instruction. Otherwise, we have more or less subject to what you
Just
say.
for a moment.
This
your
is yesterday's
lordship
judgment, my lord.
would Kindly see section 5,
Hmm.
small a.
Section 5, small.
Small a.
Yes.
Any person
Yes.
any person is in possession of any proceeds of crime,
Mm.
and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding
100.
180 days from the date of the order in such a manner as may be prescribed.
Condition.
That
Now,
is what I am asking.
any person in possession of any procedure of crime, let it presume that it is a procedure of crime.
Yes.
Is it in my possession?
That is what I am asking. That is what I have asked. Two conditions are required.
Yes.
Because the attachment itself is a fallacious. Because it is within, under the custody of the court. So where is the question? Because there must be a satisfaction of concealment and frustrating the cause. That is not there. That was my first question. Then he somehow said that we'll go to section 8. Now section 8 also same thing. It is to be the attached property relatable.
My lord,
Isn't it? It is to be attached property
my lord,
to disclose the source. When you know the source, where is the exercise of power? Let us assume that you are correct for the time being. Your allegation is correct. You know the source. Why should we ask him until and meaning thereby you are asking him knowing the source that he will admit that will destroy his defense. In a given facts of the present case, it is a peculiar case. You are saying hurriedly, you have attached properties which are within your possession.
no, my lord, my lord, I'm just clarifying, my lord. We never file an FIR, my lord.
No, we do not, we know.
So we go by, my lord, this is ECIR, this is
Yes.
internal document, my lord. So somewhere, my lord, any, my lord, police
So
authority,
that is clear from your order of attachment.
Yes, ma'am.
Where he says how it was done, who has lost complaint, how money was tracked, how it was taken, how it was seized. Now it is where in whose custody money is pending. Thereafter you say please attach it. Because you have apprehension that this money may go from either from CBI or from court and frustrate. We'll understand that only. Total non-application of money. Each case is different on a different footing. Always.
let me come back, my lord, what my lord already has
No,
indicated.
this is what we have gathered from reading the act.
No, my lord, suppose
Hmm.
in this given case, my lord, if they are not interested,
No, we will not deliberate on that. We will deliberate whether the constitution precedent required for exercise of power was there. That's all. We are limited to that.
Fine.
Number one. And number two, as Mr. Bhattacharya has argued, whether that exercise of power can violate fundamental right of a
Article
person.
20 and
If
21.
fundamental right is violated, forget about alternative remedy. That is well settled.
My lord.
Heard at some length, heard substantially, full stop. Mr. Learned Counsel, CGSC.
No, my lord, for ED.
Standing Counsel ED, pressed for some time to complete his instruction and argue further. Full stop. Prayer is allowed. List this matter on.
For vacation?
মানে পূজা তো খাই কৰিব গৈছে।
I know.
If after vacation, then it cannot be part heard.
But I have no issue before vacation of my lord. It is I'm leaving it to my senior, my lord. What do you want?
No, I have no.
Oh, okay. Then, my lord, any 26, my lord, it's a Thursday.
Last day. This 26,
No, not this September.
September
Before
26.
the vacation, my lord, only that is the, my lord,
Okay,
hearing day, my lord.
26th, okay. 26th.
That my lord will be here in this principal seat, my lord, because
Ah. This order is not under challenge, na? That attachment.
That also has gone 6 months long back.
That is gone. Anyway.
no, my lord. Since there is a stay, my lord,
Yes.
we'll get, my lord.
Okay. Attachment. Oh. What is the ground of review, Mr.?
Lord, your lordships remanded the matter
Ah.
to the appellate court to determine whether
Mm.
Schedule B land is a part of
Mm.
Schedule A land.
Mm.
My lord, that has been, my lord, answered by the defendant themselves in their written statement that Schedule B land is a part of Schedule A land.
Mm.
Now, the second point, my lord, your lordships held, that the commissioner was not examined.
Mm.
Lord, I will take your lordships to order 26. My lord, in that, my lord, in order 26,
Mm.
rule 10,
Mm.
sub-rule
Not
2,
necessary.
is, my lord, the either party will have to file an application
Mm.
if they want to, my lord, examine the
No, that
commission.
is not our view was that there is, it was not conclusive. That evidence, even if not examined by any of the disputed, but that evidence was not conclusive to come into that conclusion. This is our view.
My lord, if your
Because
lordship-
whole thing was based on that thing, that commissioner's report. But commissioner's report is not conclusive. He has said that this part, but this whether who is having which part, this was the determination to be made. Reference was that only. But
your lordship kindly see.
Hmm.
It was only suit land to be measured.
Hmm.
The suit land is schedule A and B in terms of the plane.
Hmm.
And that was measured, and after measuring, they found that the plaintiff is having.
But whole issue was for the purpose of determining who is whether there is encroachment or not. Because there is otherwise there is no dispute as regards A selling land to B. It was original land of A. Only thing is that it's who has encroached whom. Accordingly, a commissioner was appointed. On the basis of this commissioner says something that this is the position of so and so. So the learned trial court presumed on it up to it is that since it is therefore that is this. There is no evidence to that effect. So that is to be ascertained.
No, I want to clarify that point. My lord, when the survey report was given,
I think this is best case for the upstairs.
your lordship hear it to some length. Your lordship will find.
Review cannot be hard at some length. Review should be on the face of it.
My lord, your lordship will find the finding is that 5.5 latches in the, after measuring that suit land, the commissioner found 5.5 latches.
Mm.
Now, he is to get 7.4 latches.
Mm.
So obviously, my lord, the shortage of land is there.
Sortable lands may be from other side also.
No, that can't be because the suit land was to be measured and the suit land was
Yeah,
measured.
what was the dispute? This will
Dispute-
resolve every issue.
No,
Thinking of
from-
all these two brothers fight, that I thought that this would be the best way. And my view should be reversed in the upstairs.
If your lordship thinks that it's a difficult thing, my lord, because
No, I do not find anything on to review.
now your lordship's finding, my lord, if I take your lordship to that, your lordship kindly come to page 31 and 32.
I have gone through. Yes, that's why I fixed this method today. I have gone through it.
Now, if 5.5 latches is there,
Mm.
obviously, my lord, I am short of having the land. Now that clinches the issue.
That clinches the issue. That clinches the issue what? That you are shortage of land.
And
That
these
will
are-
not clinch the issue that so and so has encroached to you. Because there is no measurement of other parties' land.
these
There
are-
is the decision was that because claim is I am possessing my, you say no, you have encroached. Only your thing is measured. What is his, that is not measured. It was directed to be, only one portion is measured.
Measure means to suit land only. The suit land was measured. Because defendant's land to be measured is nobody's case.
What was the application for commission and what was the, and on that basis it came to a conclusion that you are encroachers. Otherwise, no evidence except the commissioner's report. Because that this is 5.51 that we have, I think, explained. And that view,
Apart from that, your lordship can see, these are all finding of facts. And the second appeal, my lord, does your lordship's.
no, that will not go. That is upstairs.
Legislature has
That
clearly
is upstairs.
stated-
That you have argued on in that also. That this is fine. This we have recorded your argument. That these are findings of us should not be anchored.
the
That
question
we have,
of- in
that we have
second appeal-
answered also.
My lord, second appeal,
Hmm.
it should not be a.
No, we know that.
a stage
And
of-
that you have argued. And we have recorded your argument. We have dealt with this. If my view is incorrect in the given facts, that is somewhere else to be decided.
Review jurisdiction, I understand it's very. tough to
Dismissed.
say. Applies. People.
Yeah, I have committed IA, my lord, whereby I pray that my name as respondent number 3 may be struck off from the array of parties in the writ petition, my lord. My lord, basically, my lord, they had challenged an order dated 22/7/2023, and I have joined the post on 2nd August 2023, but that is also not relevant. The deputy commissioner is already arrayed as party. So by name in person, why I need to be arrayed as party? They have no.
Any
possi-
mala fide against you?
Nothing.
Yes, there is a statement regarding this.
Where is that?
First,
Writ petition, writ petition.
in the repetition, my lord, paragraph 17, my lord, I have stated at page 32, my lord.
Page 32.
13th line. So,
Page 32.
13th line, my lord.
13th line.
So it is surprising that the decision taken by the district commissioner Nalbari with the plea of having consent of all members is just for his own conviction to take the decision for taking over the management under his authority, which is an encroachment to the fundamental right of the denomination as well as the Hindu religious people of Nalbari on Malaphides. And it has affected the entire exercise of power of by the executive committee so far management of the puja arsanas and the property of the denomination. Next, Malady, in paragraph 25A, after the order of this honorable court, the subsequent development, Malady, what was happened, Malady, that is at page 46, Malady,
Page,
46.
yes.
It is stated that the decision,
Which line? It is stated, yes.
it is stated that the decision reflected in paragraph 15 of the minutes of the meeting dated 19/9/2023. So far, the holding of the president and secretary to be defaulter, if they fail to submit the accounts and the defaulters list within 39/23, an FIR would be lodged against them for that purpose are absolutely illegal, as the district commissioner Nalbari has no power to make such a decision under the provisions of the constitution of Sri Sri Horimandir Nalbari. It is in violation of Article 26 of the Constitution of India.
Oh,
But,
you have, huh?
my lord, an order was passed by this honorable court, my lord, that the election shall be made in accordance with the provisions of the Constitution of Sri Sri Horimandir.
Hmm.
But absolutely it was violated, my lord.
Have you
Directly,
filed contempt?
my lord, I have stated in this paragraph itself, my lord, that it is a contempt, my lord. I have stated, my lord. Accordingly, in page 46, my lord,
Hmm.
fourth line, my lord. Accordingly, such act of the district commissioner Nalbari, including holding of election not in conformity to the provisions of the constitution of Sri Sri Horimandir Nalbari, in spite of direction made in the order that 4/10/2023 passed in WPC so and WPC so and so, is a contempt of the order of this honorable court, and it vitiates the entire exercise of election process.
Paragraph 46,
Paragraph, page 46, my lord.
page 46.
Just I have read the
Oh, is a contempt. Oh.
the order of this honorable court, my lord. I have annexed, my lord.
But these are basically against the deputy commissioner.
Deputy
Not
Commissioner
as an
Malafide,
individual, no, Malafide.
my lord, if your lordship see the entire facts of the case, my lord,
in paragraph.
You are aware, Mr. Chaudhary, Malafide should be specifically
Yes,
pleaded.
my lord, in
How this
in
Malafide,
paragraph 3 also I have stated, my lord.
Paragraph 3?
Paragraph 3 at page 14, my lord.
because the paragraph 32 on Malafide is not a allegation of
My lord,
Malafide.
and if your lordship go through the entire facts, my lord, then it will come, my lord. And the paragraph 3, my lord.
Be here for some time, we'll decide this entire matter.
Well, it's all right, that 14.
My lord,
etc.
if there is no substance.
You here for some time, we will not pass any order in this IA. You be here along with us,
It's okay.
we'll decide this matter.
And my
Give
lord,
it
the other aspect of the matter, my lord, I have some interim prayer in this case, my lord. My lord, the 25 in 20 paragraph 25E, my lord, the amended portion of the writ petition, my lord. I have stated, my lord, 4 of the mandirs that have been those have been demolished, my lord, without any executive meeting, and even their executive committee also illegal. That is illegal. I have challenged this. my
No,
lord,
that is the subject matter of the challenge.
challenge, my lord. So, my lord,
we
at
will
this
give-
stage,
We'll hear this matter.
at this stage, my
The
lord,
pleadings are complete.
my lord, no affidavit has been filed in respect of the amended writ petition, my lord. It is up to them, my lord, whether they will file or not, my lord.
Give a date, we'll decide this matter.
A hearing,
Give a date, no, may not be possible today.
My lord, I am not appearing as for the deputy commissioner.
No, not you, no, you are not.
So I'm not filing any affidavit.
No,
That
not
is
necessary,
the-
because there is no specific
Exactly.
anything against
My
you.
lord, my lord, I'm not
Malafide is simply, be here for some time.
in
Please
paragraph
take
3, I have
time.
stated, my lord.
Huh?
In paragraph 3, specific allegations, sir.
What is the political allegation?
Page 14, my lord. The district commissioner Nalbari, my lord, 10th line, my lord, it is stated that both the president and general secretary have been put under pressure to abide by the decision of the civil administration of Nalbari. The district commissioner Nalbari, at the instruction of the respondent minister, has kept the executive committee under pressure so far the administration of Sri Hari Mandir, and he has encroached upon the administration of the denomination to
This
ensure-
minister is also a
taking-
party.
Yes, my lord.
Then Malafide is there.
Sir, I was not holding the office. I came in September
But
2023.
subsequent, but subsequent
You be
decisions,
here
my
for
lord.
some-
My lord, we require, my lord, it may be hard finally, my lord.
We'll hear it finally, no problem on this, so provided that pleadings are completed, no adjournments are taken on the next date. Who is representing whom?
That may be fixed, my lord, for hearing. of
Who
the-
representing, Mr. Doctor, who are you are representing? A present committee.
Committee, no, earlier committee's member.
You are earlier committee's member, you are
Yes.
supporting his case.
Yes.
You are supporting his case. And
Yeah.
who is for the other respondents? 1 and 2. Do you require to file affidavit? Yes. You want to file an affidavit. When? 2 weeks time. And Mr. Who is 6? Minister, by name. Okay. And you are for?
7, 8, 11, 20 and 21.
Who are they? New present committee. Who replaced Mr. Chaudhury's committee? Okay. Have you filed affidavit?
When from the amended lordship repetition.
You have not filed. You will file or not?
Lordship will bring seek instructions, lordship will.
No, not instruction. We are, okay.
Only may I just make one prayer which this honorable court may record, that so far as this IA is concerned, it may be considered at the time of
At
hearing.
the time of hearing. Full stop. No, full stop.
3 and 4. I
At the
repeat
time of
both.
admission,
3
that
and
will,
4.
let's lie. The present application is filed by you are not here. Not now, the deputy commissioner,
I'm holding the office.
now still holding, okay. By respondent number for deleting her name from the array of the respondents. First up, it is the case of the applicant that there is no specific allegations against her, and therefore she ought not to have been made a party respondent in this petition. First up, I will consider the present IA at the time of admission hearing. Admission hearing, first up. In main, you have written it is the learned counsel representing the respondent 1, 2, 3, 1 and 2, and for respondent number 6 and
7, 8,
and the learned counsel for respondent number 7, 8,
20 and 30.
11, 20 and 30 submits that they will require 2 weeks time to file an affidavit in opposition to the amended plan. Accordingly, prays for an adjournment. Prayer is allowed. List this matter. After vacation or what?
Before vacation. only.
You want to
Yes, Malad,
difficult before vacation? It will take some time. You also know. We can fix it, but will it be possible?
at least it may be fixed, Malad.
Okay, we'll fix it. Before vacation, we'll fix it. Let us see. When? Give a date. Moshe. 30. 38.
Malad, my interim prayer may be
Okay,
considered, Malad. Regarding
Interim prayer shall be, huh?
30, I'll be out of station.
Malad,
30, this court might have also difficulty.
Malad, my
Before that,
Okay, interim prayer shall be considered
Malad, my
on the next
submission
date.
would be,
We are observing
they
it.
they have demolished entire premises, Malad. So status quo may be maintained.
No, not today. Not let us hear them. What is what?
Malad, on the next day, Malad, it may be considered.
Will the interim prayer may be considered on the next date fix. Give it on first. First of October.
I'm grateful.
Wait, please, your lordship. Your lordship, the senior engaged counsel is preoccupied in court number 3, your lordship.
Okay, see, we thought that WPC 4780 is something survived. But 4780, you have been directed to deposit 30 lakhs. That also you have not deposited. What remains?
Tender period is also over, Lord.
Huh? That is over, nothing survives. We thought because on last occasion it was recorded that 4780 and file an order at the issued by the divisional force commodity, whereby the mining contract is in favor of the prisoner was cancelled. Now that was direction was issued to deposit you 30 lakhs rupees. You have failed to deposit that. What remains? Nothing.
Let it be passed over the senior engaged
What
counsel.
are
will
passing?
appear.
Nothing is there. But yes, Gogoi.
she had prepared a small note, lordship, regarding death of event, lordship.
My lord, in this case, this is the third time the final report has been filed.
Now we have seen that.
The only thing is that what investigation they have carried out after the second final report, that is to be seen, my lord.
Hmm.
Because in the second final report, it is stated that 4 of the witnesses,
Hmm.
they have named some person.
Hmm.
And out of those persons,
Hmm.
only one person is alive. And in that report, it is stated that due to other sufficient or corroborative evidence, charge sheet was not filed against that person. So thereafter, my lord, in the year 2016, General Secretary of Alpha,
Who is representing these private respondents?
no, we have not made any private responder party.
Will it not be required?
We have not named anyone. But when there are cases of the Supreme Court, my lord, where it says
Okay.
that if investigation is to be handed over re-investigation, so it is not necessary that any accused person should be heard.
What were they said that against Jayanta, no circumstantial or corroborative evidence found. What are the materials according to you were found?
What, I'm on.
Now, after filing of this FR, that has been accepted.
That is not, we are not aware whether it is accepted or not, because informant has not received any notice so far from the court.
How do you know? See, if we'll have to give an CBI inquiry
Yes.
or in CBI inquiry here because she has some police, then we'll have to have certain satisfaction.
My lord.
Certain satisfaction. And what is the present stage of final report? That also we would like to know. And we want you to argue on the situations and circumstances and
that's
the principles under which we can exercise our power to do, because this is not a power generally is not exercised. It should be an exceptional case that you will have to show us in details.
But so far,
From the
we
that's
do
why
not-
on last occasion I have said that please go through the case diary.
but after order of the that not non-acceptance of the last final order.
Of course,
final-
if you can
What investigation they have
has been
carried
done,
out?
that will have a role.
Yes.
Because and the reason of not having satisfaction and what has been done, whether properly
Yes,
done or not,
properly
this
done or
this will be an important
Yes,
aspect
yes.
of the matter.
And my lord, even after, there are so many cases, even after acceptance of final report,
No,
after those
that is not.
cases are there.
So are we proceeding today for final disposal? Are you ready with all these material judgments and all? Up to you.
My lord, we are not aware
Hmm.
as to what further investigation they have carried out, because what in our petition.
That is what I want you to know, because already it's a final report. That's why I've said go through the case diary.
That I, because in the last order, it is not indicated, only it was handed over to.
Okay, let him go through it. Full stop. The present petition is filed seeking an independent investigation. Independent investigation in respect of Sibsagar PS case number 291, 1991, registered under section 365.30 IPC, read with section 3/4/5 of TADA Act. Full stop. The FIR was lodged by
FIR was lodged by this petitioner of this present.
the petitioner, inter alia alleging that who was killed?
He's a brother of
He-
Kishore.
That the
His
body,
father.
father,
His father.
his father was killed by the
Kidnapped and killed.
kidnapped and killed by the accused, name accused,
No. Unidentified gunman.
kidnapped and killed by some unidentified miscreants. Full stop. Till date, initially, closure report was submitted on 19/8/2010 by the investigating officer, which was not accepted by the learned trial court, and it was a reinvestigation was directed. Full stop. Subsequently, final report was submitted. When? Subsequently also, final report was submitted on 11/12/2003, which was also not accepted by the learned trial court and directed for a reinvestigation under its order dated 11/12/2003.
2003.
Subsequently, and subsequently, reinvestigation was done, and once again, final report was submitted on a similar ground that 4 of the accused has died, and against one accused, no circumstantial or corroborative evidence has been found. However, such final report was also rejected by the learned trial, was not accepted by the learned trial court, and under its order dated 15/7/2008,
Eight lordship.
reinvestigation was
Very good.
2018, isn't it?
2008.
2008, reinvestigation was directed. Again, a final report was submitted on 5/9/1989. Same,
19, my lord.
2019. 2019.
19/8/2019.
19/8/2019. 19/8/2019. Full stop. Mr. The learned counsel for the petitioner submits that the learned trial court has not was never satisfied with the investigation carried out. However, the investigation has not properly been done, and therefore investigation by an independent authority is required. He further contends that the material collected and determination made between the direction of reinvestigation by order dated 15/7/2008 till the submission of final report on 19/8/2019 shall have a bearing upon the determination of this case, and therefore he has made a prayer that he may be allowed to go through the case diary. Full stop. As the final report has already been submitted, this court is finally submitted and matter is having importance, this court permits the learned counsel for the petitioner to go through the case diary in presence of the learned Mr. K. Gogoi, learned state counsel.
Unless also before a registry, he can lordship. That's because.
You keep it. You keep it.
Lordship.
Both of you sit over for a cup of tea in your office and go through it.
Lordship.
Okay. Case diary be retained by Mr. K. Gogoi till the next date of listing. List this matter on.
Next week, my lord, next Thursday.
Next Thursday will be a difficult proposition. First of October.
Lordship.
First of.
And note may be kept as a part of the record.
Mr. Gogoi has given a note on note and list of dates which is kept on record.
1st of October, I have some difficulty. I will be out of session, my lord. Beyond
3rd of October.
I will be out of session.
Kolkata.
Nagaland and that too fake. Can it be on 26?
26 may be a difficulty because this court may rise a little bit early. 27th is a Saturday.
Then let it be on
Huh?
1st of October.
27th is Friday. 26 we can give a try. At least we'll not, if we could not complete also, then we'll see a try. Otherwise we'll go to after vacation. Mr. Please have this our principle
Right.
when we can exercise.
Yes.
And that basic fundamental is that these are the principle and this principle can be applied to the given facts of the present case. That's all. Otherwise not. Yes.
Because from the last occasion, there was.
Yes, Lordship. Total land was acquired, Lordship, 6 bigha, Lordship. And
Mm.
business share was, Lordship, 1 katha, 17 lakhs.
Mm.
And his total entitlement of this plot is 2590, Lordship.
Mm.
But the requiring authority has not provided the money, Lordship. So we have
Who is requiring authority?
PWD, Lordship. We have written several letters to them, Lordship, in long back, Lordship.
What is this trend? Why you start acquisition without money?
And petitioner's land was 1 katha, 17 lakhs.
What is the due to her?
At that time, it was mega, Lordship. It was 2590, Lordship. But it is long back, Lordship. Old acquisition.
When?
It is, Lordship.
Yes, PWD. Who is for the PWD is a party?
What is that? Yes, Lordship.
That part.
Six.
Yes,
After that, I'll get my senior. Mr.
Mr. Goswami, learned State Council, comma, pursuant to this court's order dated 21/8/2024 and 19/7/2024 has obtained some instruction. According to him, the land of the petitioner was acquired. However, money could not be paid for the reason that
No, that is not true, but it is written in your instruction, Lordship. It is not known whether the compensation of the land has been released in the favor of the petitioner or not. But money is also not received entirely, Lordship.
you say something that money not received, not received.
Money was not received.
So money not received, then how can you say that we do not know whether money, who will pay money? Collector will pay the money.
Lordship, and to tell land was
Some
acquired.
instruction accordingly.
Yes, I mean,
He prays for some time to file an affidavit in opposition. Prayer is allowed. List this matter on, give a date after vacation. In the meantime, the respondents may file their affidavit.
but PWD may file affidavit, Lordship, because
That we do not know. If they have not paid, they will pay with 10-12% interest.
21.
not obliged.
First, we want you stand, then we can get hold of them. You file an affidavit, then either you pay. If you say that no, we have done it, but no money, then you will pay. And if you say that we do not know, then we'll see.
Active hold of the law.
Maybe.
My lord,
Where is your notice to you?
friend of my lord, private respondent,
Where is the notice?
says there, my lord, page 34 is one,
Page,
page 34 is the first notice.
page 34. And then,
My lord, the last page, my lord, page 48.
huh?
Page 48.
Page
Is the second notice,
48.
48. First notice, my lord, not under rule 18. But second notice is under.
Yes, where is the complaint?
My lord, complaint copy that did not supply.
Where is the complaint?
May it please your lordships, the encroachment of the private road, which was used by the respondent number 4, 5 and 6. Purely that land is the government land. But the petitioner illegally encroached the said road, my lord, leading to the main road. And after encroaching and constructing the main gate in front of that private road, my lord, then the respondent filed the miscase before the concerned circle officer, and after field verification, the circle officer found that the road which was encroached by the petitioner, that it was fall under Dokhingaon village.
Where is the report of the circle officer?
Your lordships may kindly peruse the affidavit submitted by the circle officer. Your hand, my lord.
Respondent number 3.
Affidavit. Yes.
Respondent number 3.
Respondent number 3, my lord. Page number 3, para number 7, my lord. May I read? That with regard to the averment made in paragraph 7 of the writ petition, the deponent begs to state that it is to be mentioned that the land of the entrance road leading to the land of the writ petitioner has no mention in the sale deed of the petitioner, my lord. As per revenue map, the land falls under the
Paragraph,
Kinga
paragraph.
Revenue Village.
Paragraph.
Paragraph 7, my lord. Page number 3, my lord. As per revenue map of the land falls under Dokhingaon Revenue Village under Beltola Mouza. During field verification, it is seen that the writ petitioner's family and the family of other two persons, namely Prafullo Thakuria and Roseshwar Bora, have been using the aforesaid road. It is to be mentioned that the aforesaid road is the only approach road of the two families, that is Sri Prafullo Thakuria and Roseshwar Bora, leading to the main road, my lord.
Now, where is the statement that this land is a government land?
Yes, my lord.
Paragraph 9.
Paragraph 9, page number 4, my lord. Yes, you can say. And your lordship.
Okay, since we
Your
are giving him a
lordship.
chance, give a copy of the inquiry report, issue a fresh notice and decide it.
Copy of complaint they filed, my lord, and report also. My lord, can you see?
Tell us what is your case.
No, my lord.
Tell us what is your case. Show us that it is your land.
My lord,
You are a doctor. Can you block this?
my lord, circle officer filed, my lord, this affidavit. No trace net, no, my lord.
Okay, tell us your case.
Yes.
Then we'll finish
My
it
lord,
here. We'll
my
we'll
lord,
finish it here right now.
My lord, I purchased land in 2004.
Hmm.
2004. And since, my lord, 2004, I am there constructing my house.
No. They are saying that this is a land, government land. What is your reply to that?
My lord, government land, my lord, report is also not there. My lord, Sita copy is also not there. Only their verbal.
No,
my
what
lord.
is your case?
My lord, I
You
am
say this is your patta land.
My lord, yes, my lord, I have enclosed, my lord, my deed. Deed also. And lecture 1 is my deed, my lord.
So we'll say him that they will verify in presence of the petitioner with the revenue authorities, and if it is if it is just the government land, they will demolish it. That's all.
Jamabandi, all these documents, my lord, I have submitted.
Okay. They will go do a field verification in your presence with the documents, and if it is a government land, it will be demolished. No chance. Hard. Mr. S. Sohan, Ranjit Counsel for the petitioner. You are Mr.
Mr. A. Hussain, my lord.
A. Hussain, Learned Counsel for the respondent number.
Your
Karagote,
lord-
Mr. S. Borua for the state respondents. C is for Bordoloi for Revenue Department, Standing Council Revenue. The petitioner claims that he is pattadar of a land measuring 1 katha 5 lessas covered by Dag number 286 within bracket old 1063 new of KP patta number 56 old / 625 new at village Kahilipara under Mouza Beltala in the district of Kamrup within bracket metro, which according to the petitioner, the petitioner has purchased with with his brother-in-law, namely Arun Kumar Datta, from one Srimati Soroju Sharma by executing a registered deed being deed number 4114 dated 4/6/2004. According to the petitioner, the said land of the petitioner is now covered by Dag number 1063 new and Patta number 625 new at village Kailipara under Mouza Beltala in the district of Kamrup Metro as renumbered as Dag number 1095, Patta number 296. By way of the present writ petition, a notice dated 12/5/2022 issued in Miss Case number 207/2021 by the Circle Officer DVD Dispur Revenue Circle, directing the petitioner to remove an iron gate, alleging that the gate is constructed over government land covered by Dag number 628 of village Dokingao, Mouza Beltala in the district of Kamrup Metro, and further directed him to remove the encroachment over the said land, informing him that failure on his part to comply with the same, he shall be evicted from the said land under the provision of Rule 18 within bracket 2 of the Assam Land Revenue Regulation 1886. Mr. Sohan, learned counsel for the petitioner, submits that though first notice was served upon him on 12/5/2022, however, such notice is without any schedule / boundary of the land involved in the case. Full stop. It is his further country's and it is his further case that he has not been given any reasonable opportunity of hearing to present his case. Full stop. It is also his case that the inquiry report that the inquiry conducted by the circle officer in this regard, which is disclosed in the affidavit filed by respondent number 3, is also known to the petitioner only on filing of such affidavit, and he is not aware of such inquiry report. Therefore, his right is sought to be violated without following due process, without adhering to the principles of natural justice. Per contra, the learned counsel for the respondent number 3, relying on the affidavit, submits that a complaint was lodged by the respondent number
4, 5, and 6, ma'am.
4, 5, and 6, internally alleging that a public road has been blocked by the petitioner, resulting in difficulty in egress and outgress of the respondent number 5, 4, 5, and 6. And on the basis of such complaint, the miscase was registered, and accordingly accordingly a notice was issued. However, the petitioner did not respond to such notice. Did not respond to notice. In the aforesaid backdrop, an inquiry was conducted through the circle officer, and after the inquiry, it was found that the land over which the gate was constructed is a land covered by DAG number 628 of village Dokingao, Mouza, and it is recorded as government land. Full stop. Full stop. It is also a stand that a date was also fixed for such inquiry on 22/03/2022. However, petitioner was not present on that day, and subsequently he filed certain documents which are annexed with the writ petition as Annexure 8 and 9. Annexure 8 and 9 on 13/4/2022. However, as the inquiry was already over, such documents were not accepted by the circle officer. Full stop. Accordingly, in view of the aforesaid, the petitioner was asked to remove the iron gate which is constructed over a government land. Full stop. From the aforesaid, it is seen that though notice was issued to the petitioner, however, the petitioner did not avail such opportunity in the case. However, in the interest of justice, it is provided that the circle officer may measure the land in presence. Circle officer shall measure the land, disputed land, in presence of the petitioner, and the respondent number
4, 5, and
4,
6.
5, and 6,
my lord.
along with revenue staff, and after verification, it is found that if it is found the petitioner's land is petitioner is encroaching government land, he may be evicted forthwith. Full stop. The
Please, your
when
lordship,
will be present in the plot of land? Tell us, give it date.
some time may be given because my lord, I have to contact and inform him also. 2 weeks. Almost lots of time was granted by this honorable court, my lord, in earlier many occasions, my lord.
To do what? To do what?
Just for adjournment of the case.
So we have not adjourned today.
Yes, my lord.
We have disposed it of.
Yeah.
My lord, I am from 2004. They have come after
Maybe
2016.
2004, if you are encroaching a land, government land, a road, you are liable to be thrown out. Whosoever you may.
In
Uh,
the
My
schedule,
lord,
in-
And when you
in
can, the
the
circle officer shall complete such exercise within a period of,
After 2 weeks.
within a period of 3 weeks
Hmm.
from date, from receipt of receipt of an order passed today to be furnished by the respondent number
4, 5, and 6.
4, 5, and 6. You will not furnish, he will furnish 4, 5, and 6.
That inspection date, the petitioner has to be present. Again, if at all he
You-
denies to have received
come
a
on.
notice.
If the demarcation and demarcation and verification be done on,
A date may be fixed.
give a date. It is requested by Mr. Borua that a date may be fixed for
Yes,
such verification. Otherwise, the petitioner may not appear on the notice of the circle officer like the earlier occasion. Full stop. In view of such submission, it is provided that the demarcation and inspection be made on
Saturday? No, 2 weeks.
Verification is not correct because my lord, I was.
Not correct. We are not saying correct. We are not saying correct. Otherwise, you could have said that this is the stand of circle officer, nothing, you are go out. We are giving you a chance to place your question. Yes,
27th of September.
27th of September, 2020.
Highly obliged.
Dispose of.
Adjourn for 2 weeks, my lord. The petitioners are willing to engage another sets of counsel.
Okay, it is submitted by Mr. Padgiri that the clients want to engage some new set of counsel. Accordingly, matter may be adjourned. That is allowed. Please this matter after puja vacation.
Obliged. In this matter, lordship may kindly take up the matter at 2, lordship. It will take some time, lordship. 5 minutes.
Okay. Not at 2, we'll finish the other matters then only. Yes, next. Yes, Doctor, neither here nor there.
There is, I want to point out some textual aspect. Let's say. There are 2 petitions are there. One disclosure petition. Both the petition they are claiming land acquisition compensation for same plot of land.
Okay.
Right order detail, let's see. The earlier the disposal of case has been 5/4/6/2014. The earlier case has been disposed of. On the ground that relief sought has been received. That from that aspect, logic, somebody has received the amount, logic. The factual disputes are there. Secondly, there is some delay, logic. Delay of 42 years approaching this court from the date of his knowledge, logic. That's on similar ground, logic. And division bench has dismissed on repetition, logic. Only delay ground, logic. Most probably this will cover the whole case, logic.
আপোনাৰ কাম আছে। ফ্ৰেছ দিব ৰমজানটো উলিয়াই থৈছে সেইটো কোৱা। সেইটো ৰিলিফ চব সেইটো আমাৰ মাজত এখন এগ্ৰিমেণ্ট হৈছে সেইটো বেয়াটো বেলেগ আছে সেইটো বেলেগ কথা বেয়াটো বেলেগ আছে উইড্ৰন বেলেগে আছে
What is the single judge's order?
I have looked. 2906.
Okay, we'll come back. Yes, you go through this judgment. Today? Or huh? We'll hear it today. See, there are some gray areas.
Yes.
What happened to the earlier, somebody has taken the money.
No,
Uh,
you're allowed to clarify. What happened during the pendency of the other writ petition that was filed by the nephews of the present petitioner. Then during the pendency of the writ petition, they had this internal agreement. That is the reason they withdrew the writ petition back. Not that relief is sought. Relief, we had
Did they
agreed,
get any money?
no, we agreed to share the money.
Now, where are they now? Are they petitioners here?
No, they were the petitioners in the other writ petition where my learned friend has pointed out the relief sought has been granted. Relief sought has been granted was, I mean, the interpretation was wrong. They entered with an agreement.
No,
with
no,
us.
we are not on interpretation. If somebody says relief
Yes.
granted, means the compensation
In
received.
that petition, he was a
Then
party
there may
respondent.
be a question of apportionment, then
Yes.
there may be a question of section 11. These are there.
Yes.
If you are ready, we'll proceed.
Yes, my lord.
Yes.
The agreement is there. We entered into the agreement.
No, no, agreement we cannot go enter into. In a writ court, we cannot enter into who gets, who will not. Until and unless they are here and they says that, yes, we have not received. That is a different issue.
Yes, yes, if need be, they will file an affidavit. If need be.
So
they will
that's why
file-
I'm asking,
Yes.
are you ready for?
The thing is that the interpretation was wrong. Relief sought.
Mr. Counsel, please listen to us. We will go by an order of this court. Can we say no, that interpretation is wrong until and unless a review is
Review,
sought by us?
yes.
That is not permissible. Second thing is that if somebody claims admittedly against the same land, relief is granted, we'll presume, and if you have a claim, you'll have to may go for 11. And whether there is any notice under section 4 and 6 in this case.
It's not.
Any annex, notice annex, acquisition notice?
One number is an
No notice.
Government has filed an affidavit, that's it. One.
I've seen that, that's why.
Affidavits are there, my lord. It's not containing this one.
Okay. Let us see, understand the facts. Jogesh Paul, isn't it?
Yes, sir.
That is the petitioner.
Yes.
When land was acquired?
That was in 1968.
Nineteen 68.
My lord.
How you say that this land was acquired by which land acquisition case?
My lord, that is LA case number 9. Of
How do you
636.
get any relevance of LA 9? Any documents,
Yes,
material?
yes, my lord. What you would see is 23, the writ petition. And it's a one series.
Page?
Page 23. That is the translated and type copy of the cheetah.
When have you claimed land acquisition compensation? Since they have raised an objection as to the delay,
Yes.
we'll have to understand that.
Affidavit. Now lordship will come to my additional affidavit.
Filed by?
Ask the petition. Okay.
When the writ petition was filed?
in 2012.
Huh?
2012.
2012. You have last filed the representation on 22/2/73.
Yes.
Thereafter, you filed the writ
Thereafter-
petition in
Thereafter, we file RTI.
RTA when?
RTI application. Let's see the.
Because RTA came in the year 2005.
2011, RTI file.
Huh?
RTI file 2011.
2011. RTA file when?
The application file 23/3/2011.
23 to 2012.
23. RTI.
RTI was first RTI was filed on 22/09/2011. Annex 3, page 28.
Ah, 27. 27. It's 27 years. Twenty-three.
Appeal. Appeal. Reply na palo. Then in the writ petition, my lord, page 34. Annex 9.
When earlier writ petition was disposed of by the co-pattadas?
4/6.
4/6.
4/6/2014.
Record is in the. There is also tag record.
When this register shows when received, money received, there is a signature. With the additional deputy commissioner, he showed that. Where is that? What was the date?
No. Not.
Yes, Mr. Anything?
On textual as well as it.
That officer has shown us something. Whether that date is relatable to this withdrawal of writ petition, that is what I want to know.
Yes.
Because money, according to the additional deputy commissioner who was present on last occasion, he showed a register.
Yes.
Because you have in the affidavit, you have taken a stand that we can show from the register that money has been paid to the landowner.
And
Now, what is the date and when this writ petition is withdrawn? Earlier writ petition, because earlier writ petition, it was said that
earlier, earlier case record is there, Lordship, tag with this present.
no, that we know.
That's it.
Yes, yes. Now you tell us, have you gone through their recent affidavit?
Yes, sir.
They tried, but there is no record after how many years?
42 years, Lordship.
42 years. We
Till
cannot
2012.
blame, we
Till
cannot,
2012.
we
42
cannot blame them.
No, I don't, okay, we cannot blame them, my lord. But thing is this.
And they have taken a stand that money is paid. There is a receipt signature in the receipt. Somebody came and said, we are satisfied. Where is that writ petition? Let us see. What was the claim in that writ petition? Difficult, it will be difficult to.
Another factual aspect, Lordship. They claim for land acquisition in the year 2072, 16/1/72, and representation is received by the respondent authorities on 73, in the year 73, after 1 year and then subsequent after 2 years.
No, no, that other writ petition which is
Where is the signature of the register? Where is the register?
other writ petition, other.
One register was there, lordship.
Ah.
One register was earlier brought to this court, and now that register is not there.
No, that will be there. That will be there. Where will it go?
You can produce it, produce it. Also would say what? Para 20, page 15 of the earlier read petition.
What is the LA case number?
LA case number 9 of 6869.
What is your land claim of land?
Hello?
Total land you claim?
Total land was 13 bighas, 3 quarters and 16 lectures.
KP patta number?
Annex of 1 series.
Just tell us. What is your name, your petitioner's name?
Yogesh Chandra Pal.
Yogesh Chandra Pal.
Huh?
Yogesh Chandra
And
Pal.
who is this Amulya Das?
They are the nephews of Yogesh Chandra Das.
In that case, Lordship, the petitioner is also party respondent. Respondent was 6, Lordship. In this case, Vinod Das, Lordship.
I've seen it.
That's
That number. KP patta number 1, window bag number 2. Number 240.
Yes.
So for the delay part, my lord.
Not only delay, many things you will have to answer. How will you decide who gets? Because admittedly, you had a title suit. Admittedly, other party claims that you are trying to deprive them. Therefore, they have filed a writ petition. Now, are they parties in this writ petition? In whose favor will pass? And admittedly, they claim to be under same land and that they inherited from your grandfather, your father, their grandfather, I think.
Right.
So how will you decide all this in this writ petition? Forget about delay.
The delay, I'll not, on that point. Thing is this, they are nephews. I am the recorded pattadar of this land, and these has been verified by the order of this court.
No, that we understand, but
The order of this court.
but when it comes to our knowledge that somebody also claims and they said that they have really received, got the relief and the agreement you are saying is an agreement relatable to the title suit. Title suit, they said the title suit was withdrawn, therefore a compromise, an agreement that you will pay them. They said we have received. How much they have received in absence of?
In their petition para, what, 20 page 15. They agreed that we have assured them that you will get your payment, whatever she want like. So accordingly, the title suit was withdrawn. So that is the relief what they were talking about this writ petition.
No, thereafter they filed a writ petition.
They filed writ petition because there was no agreement. They thought
They filed a writ petition and they said, please give us the land acquisition compensation. Now they say we got the relief. In their absence, we do not know.
now, if lordship permits, we can get an affidavit. The other writ petitioners as well as the present one is not there, but his legal is here. The thing is this, that is actually, I mean, that is not material to this case, madam. Because I am the petition, I filed in 2012, they filed a title suit, whereas their name was nowhere there and the land was acquired. What relief they would have got in the title suit also? I'm just talking about it, off the record. They would not have got any relief in the title suit also. In an acquired land, can a man apply for right title in his case?
That is not the subject
So that
matter.
is gone. They simply want money and we have told them that you'll get your share after we get our share. So that way it has,
Admittedly, they are also entitled for land acquisition compensation.
they are not entitled. Nowhere they are entitled. Because these particular land belong to the
No,
petitioner.
you have said that we have
No,
assured them.
out of
You have
a-
assured them we'll give you a
out of
share.
a humanitarian
No,
ground. And thing is this, we didn't want to litigate for long. Whatever money we get, we'll share. Simply we put it that way. Otherwise, you file a case, I'll file a case, and it will go on lingering and lingering. So that was the reason we compromised. And nothing else. And prima facie, they have got no legal rights over the said plot of land, which has been acquired. But out of humanitarian grounds whatsoever, I mean, out of affection, being the nephews, and I be the uncle. So it was a settled issue that we'll give you some money. So that is that, nothing else. So relief secured as interpreted was that we promised that we'll pay you. You don't litigate.
but that promise was there, that agreement was there when writ petition was filed. That relief, if you say that they have got the relief, they got the relief prior to filing of this writ petition.
Not prior
Because
to-
that was a part of
not
the
prior to
writ
filing-
petition.
Not prior to filing this.
It is a part of their writ petition. They have annexed that.
Not prior to filing the, after the filing of this particular petition. Not prior.
They have made a specific statement here.
They filed the writ petition in 2014. We
Hmm.
filed in 2012.
Hmm. Hmm. Anyway,
So if lordship directs, I can get an agreement.
we'll not direct anything. We'll
I know,
decide
affidavit-
on the,
affidavit, sorry.
on the basis of what is available. It's too late on a day today. 2014 matter we are hearing. We'll not direct anything. We'll decide if you proceed on the available on record.
As lordship pleases. As lordship pleases. Lordship has the copy of the agreement.
Yes.
Kindly please go through it.
So this was filed on 29/10/2013. Isn't it? This is a part of the pleadings of the writ petition.
Yes.
Yes.
Thereafter, they filed this writ petition and they say we have received
This is
the amount or we have received the relief.
Really.
Even after this, they have filed this writ petition. These disputed things will be difficult. Award was in favor of whom?
Supreme Court to दिया, लेकिन वहाँ- तो दिया।
The agreement lordship whereas the first party was filed this petition. So before the other party, High Court for payment of compensation of the said land. And both the parties are entitled to get the share of the said. The agreement.
Yes. Yes, proceed.
Now, my lord, so far as the contention of being paid the compensation. So, you are like to cite a decision from the Supreme Court. With the interpretation of statute, awards paid in section 24(2) Act 2013, different than offered or tendered. However, paid cannot be construed to be a receipt of compensation by the landowners, persons interested. Having regard to 31(2) of the landowner, compensation may be paid to have been paid when the collector discharged his obligation and deposited the amount of compensation in court and made the amount available to interested person to be dealt with as provided in section 32 and 33 of the Act 1894. So this is a moot question.
Are you having the register?
The register has been taken back by the.
Can you bring it?
So the amount is said to have been paid when the collector discharged his obligation and deposited the amount of compensation in court. No proof, nothing.
We'll just see the that was produced on last occasion.
Yes, please.
The collector, by often filing an affidavit, has taken a stand that an award was made in connection with the land LA case number 09/68-69, isn't it?
Yes.
68-69, and the awarded amount was paid. It was a further stand that the said register can be produced before this court as and when required. Full stop. As and when required. It is the case of the petitioner that their land was acquired in LA case number 9/6869 in the year
68.
1968. However, when no payment was made, even after their repeated representation before the collector, which were filed on where are the dates?
Representation to the
Huh?
16/172.
Which paragraph?
Additional affidavit.
Additional affidavit. On 16/1/1972, 20/10/1972, and
Yes.
22/2/1973. They has approached this court.
And
I-
RTI application.
They have
filed.
they have approached this court in the year 2013,
12.
2012, 2012. It is their further case that they came to know about certain information. They could obtain certain information through RTI in the year 2012 and accordingly filed the writ petition in the year 2013.
2012 onwards.
It is also on record that another person claiming to entitle for land acquisition compensation against a land measuring same land filed WPC 1354/2014, airing the present petitioner
Number 6.
as respondent number 6 in the writ petition, inter alia alleging that though their names are not recorded in the land in question, however, he has inherited the land from their common predecessor interest of the petitioner in WPC 5868 and WPC 1354 2014. However, subsequently, said writ petition was withdrawn on the contents that they have been granted the relief sought for. Full stop. Granted sought for. In the aforesaid backdrop, the learned State Council has raised an objection as regards delay and losses on the part of the petitioner in approaching the court after almost 40 years.
42 years.
42 years of the land acquisition, inasmuch as a specific stand has been taken by the respondent revenue authorities in the affidavit that even after much search, they could not gather such old record to ascertain the claim of the petitioner, inasmuch as they made a specific statement, as recorded here in the above, that the payment was made and it is reflected in the record of receipt register. Full stop. Accordingly, let the respondent authorities produce the receipt record on the next date fix. Please this matter after vacation.
Matter may be kept part heard.
It will come after vacation. After vacation, it will come before this court. 22nd of October. Come. In your case, they are not parties.
No.
In your okay. Yes. Mata 345.
Pending items 3, 4, 5.
Nothing is there. I have gone through. We cannot adjudicate. Even the sums given to you.
No, my lord, we have already for that, my lord. for like rupees 30 lakhs. We have already filed a miss case. As per the order of the honorable court, we wanted to deposit it. Kindly see the my
Now, what kind of relief do you want as on date?
only to return back our money.
Return back what?
My security money. my lord.
We'll
My lord, kindly
relegate
ca-
you
my
to
lord,
them and
kindly-
they will consider your case.
My lord.
Yes,
Kindly-
forest. Who is forest or mining? Who is here?
They are only in one case, my lord, they have filed affidavit in the first case, my lord. Since then, my lord, no affidavit is filed in either
Mr.
in this case
Bhattakur
or
was
in
here.
the main case, my lord. We cannot, we could not even know their stand, my lord. My lord, kindly see the interlocutory application 1623 of 2015.
For how much money?
For 30,000, for 30 lakhs, we wanted to deposit, my
No,
lord.
no. For how much amount security deposit?
It was 33 lakhs 46,333. That is the security deposit, my lord. We have also filed, my lord, IA, my lord, that was on last occasion that was disposed of, my lord. And they, my lord, arbitrarily issued the order, my lord, when there is a stay before, by this honorable court, my lord, by the honorable high court, my lord.
Stay
They-
was conditional. Stay was conditional deposit of 30 lakhs.
Yes, my lord, that
And
was
there
done-
was a record, it was recorded in subsequent orders that you have
Yes,
failed.
but within 2 weeks,
have
the
failed.
honorable court, my lord, no, my lord, honorable court directed.
No, there are orders which records that you have failed.
No, my lord.
Yes,
Kindly
let us-
see, my lord, interlocutory application 1623 of 2015, my lord. In, that was filed as we could not collect the, my lord, Salan, my lord, to deposit 30 lakhs. So,
Yes,
they
where
filed
is
this,
forest? This is the difficulty. Difficult. Huh? Okay, wait for
my
some.
lord, we wanted to deposit before the
We will
rate
have an
also, my lord.
see, security, it is a security deposit.
No, my lord, it is the kist money, my lord. That was the kist money as per the order of the
No,
honorable court.
What do you want now?
Now,
Refund
my
back
lord,
is?
as the contract is already over, my lord. So we should get the, my lord, our security deposit as it is, the contract was given to someone else
Yes,
arbitrarily.
Bhattakur only she wants her security deposit to be returned.
Lordship, we need some time because we did not have the brief.
Will impose upon you 30 lakhs cost. This is a matter pending since 2014.
Lordship, but we
Will
did
compensate 30 lakhs cost.
appear before Lordship. We just need some time to reconstruct the brief.
No reconstruction of brief. Have instruction by Monday. As regards refund of the security deposit.
Yes.
Heard MS Sakuria, learned counsel for the petitioner. Also heard Mr. I. Bhattakur, learned standing counsel for the forest department. Full stop. WPC 4103/2014 was filed seeking a direction to the respondent authorities to make a reasonable and judicious decision on the availability of sand for extraction from Batha River mining contract area number 2 under Loharghat Forest Range, Kamrup district for the period from 2013 to 2020, during which the petitioner was the mining contractor for that area. Full stop. It is admittedly the period of mining contract was over. Period of mining contract was for the period 2013/2020. Full stop. Thereafter, during pendency of this writ petition, WPC number 4266 was filed, assailing an order dated 10/5/2016 issued by the Principal Chief Conservator of Forest and Head of Forest Board Assam, Assam, on the ground that the said conservator has granted mining permit allowing mineral concession within the area of mining contract of the petitioner. Full stop. Subsequently, WPC 4780/2015 was filed, assailing an order number 208 dated 3/8/2015, issued by Divisional Forest Officer, Kamrup West Division, whereby the mining contract issued in favor of the petitioner was cancelled. Thus, after expiry of the initial mining period, nothing shall survive in respect of WPC 4103/2014. Now, similar shall be the case in respect of WPC 4266/2016. Full stop. So far relating to WPC 4780/2015, this court initially 4780 initially granted an interim protection under its order dated
14/8/2015. 14/8/2015, my lord.
under an order dated 14/8/2013 to the effect that subject to deposit of an amount of rupees 30 lakhs within a period of 2 weeks from 14/8/2015, the operation of order dated 3/8/2015, which was put under challenge in WPC 4780/2015, shall remain suspended. However, order dated 4/5/2016, passed in the aforesaid writ petition, reflects that the deposit could not be made in absence of Salan or want of particulars under what head the payment could be received. Be that as it may, it is an admitted position that 30 lakhs rupees was not deposited. Full stop. In the meantime, the period of contract has also been over. Therefore, at this stage, MS Thakuria, learned counsel for the petitioner, submits that the petitioner had suffered a lot and above all, the security deposit amounting to rupees
33 lakhs.
33 lakhs 46,000
333.
333 is still pending with the forest department, and in the meantime, the mining contract was entered with some other person so far relating to the mine in question. Full stop. At this stage, the forest department has not filed any affidavit though the matters are pending since the year 2015. However, at this stage, Mr. I. Borthakur, learned standing counsel for the forest department, seeks for a week's time to obtain instruction whether the security deposit can be refunded to the petitioner. Full stop. List this matter on after 10 days.
Kindly date may be fixed.
We are fixing it after 10, 23rd
Obliged, my lord.
in the orders column.
Right.
In the orders column.
17.
Yes.
Lord, these are land acquisition matters, Lordship, where the acquisition proceeding is under challenge. Lordship, for quite some time I am not well.
We are well, we'll read the brief. You can take your seat.
Lordship.
Yes.
That acquisition proceeding is under challenge, land acquisition proceeding, for not fulfilling the mandatory criteria of Section 4 of 1894 Act, for which again the petitioners before your lordship could not file the objections under Section 5A. And when the interim order was operating, lordship,
It is acquisition for what?
widening road.
National highway,
No, Lordship.
widening of road. Which road?
State highway from, it is from Palitakuchi to Barbata. Our is Borkhetri under Borkhetri Revenue Circle.
Hmm.
All the three petitions
Now,
covering several. So that declaration was made after mandatory period of 1 year. In the meantime, Lordship, that new act came, 1/1/2014.
now please tell us when the notice under section 4 was issued.
In 2013.
Date.
But it says,
Who is this respondents, private respondents? Or what? Who is appearing?
Page 74, Lordship, and accepting series.
Page
72 onwards.
$72.
2013. 2nd May 2013.
What is the ground of challenge?
Lordship, section 4 notifications were not circulated in the manner as prescribed in the 1894 Act.
Okay, first ground. Then
In the meantime, with the Lordship, that new Act came, 2013 Act, 1/1/2014.
when that's why I'm asking. Section 4 notice was given when?
May, it was 2nd May 2013. And law is as such, Lordship, that declaration should mandatorily be made within 1 year.
When 2013 when the award was passed?
No award was passed, Lordship.
What no award was passed?
No award was passed. After declaration of sections 6.
So nobody has got any you have not
Yes.
received any
Any
compensation.
We are in possession, we have not got any compensation. Our case is, since the entire proceeding has been lapsed, Honorable Supreme Court, that.
Oh, we'll come to Supreme Court later on. We know.
That a constitution bench judgment. And their proceeding lapsed. We are seeking a de novo
What
proceeding.
that we need a specific date. Paragraph 600 something. Which judgment you are relying on? Constitution bench.
That means. on
Indoor
lapsation-
development.
Lapsation, the last judgment, Lordship.
Which last judgment?
That 2028.
No, name of the parties.
Indoor development.
That
Authority.
is what I am saying. Paragraph 699 or something like that. Which paragraph? Summarized.
363.
Huh?
363.
363.
360.
66363.1. Isn't it? Then we should know the dates, when notice was issued 4, when 6, when award was passed, then only you can apply. So you will straightway go to the Supreme Court judgment without knowing the facts.
Lordship, that
On the prayer of the learned counsel for the parties, matter stands adjourned and be adjourned signed. Don't come here to show your faces.
Lordship, I'm quite annoyed, Lordship, for asking.
What is the present status?
Sealed.
Actually, our instruction was of 11/1/2022.
We do not know.
Actually,
We do not know. This is the way you are dealing with a person. We'll award that how much compensation you are claiming.
Lordship, let me have the
Our
current status
total
because our instruction was
46
of
lakhs
11/1/2022.
41,900.
What is the judgment, recent judgment?
Is, I do not have Lordship, but total due.
Yes, yes, that dwelling houses cannot be.
Lordship, because of the pendency of this case, as per 20.
What pendency of this case?
11/1/2022. as
No,
per
no,
our
this, we
instruction,
will not
Lordship,
spare this
that
person.
was.
What is the judgment?
Husband, I am not recalling Lordship. Dwelling house cannot be.
Yes, Mahanta. Who will say the judgment? An RCC building belonging to the petitioner was admittedly sealed on 21/04/2015 during the course of an investigation in connection with Bishwanath Sariali Police Station case number 108/2015. It is submitted by the petitioner that such house is still under seal condition. According to the petitioner, he has represented before the Superintendent of Police, District Bishwanath. However, it is still under sealed condition. It is available on record that the petitioner rented the said premises to one what is that? What was that organization?
Abhishek Traders.
Messrs. Abhishek Traders, who is the accused in the Bishwanath Sariali police station case number
108.
108-2015. 15. And there is no allegations against the petitioner, only for the reason that the aforesaid premises was used by the accused. The house has been sealed and till date that is under sealed condition. The Honorable Apex Court in Suencho versus Suencho has clearly laid down the following propositions of law. Full stop. In view of the aforesaid, as an interim measure, it is directed that the respondent, Superintendent of Police, Bishwanath Sariali, shall ensure that the house is desealed and possession is handed over to the petitioner forthwith. However, the investigating authorities shall be at liberty to seize other materials that might be kept inside the premises by the accused. What is that? Accused Abhishek traders. Full stop. This court is surprised to note that a dwelling premises slash rented premises has been sealed in the year 2014 and it is 15 and it is still under seal condition. And this court is also of the prima facie view that such action is illegal, subject to, however, further deliberation and perusal of the case diary of the concerned police station case. Therefore, this court may also consider for granting damages and compensation in the given facts of the present case in exercise of its jurisdiction under Article 226 of the Constitution of India. Therefore, in the afforded backdrop, let the Superintendent of Police / IO of the case file an affidavit by the next date fixed and also produce the case diary of Vishwanath Sariali PS case number 10815. List this matter 10815 under 10823 under section 120 within bracket B/420/406 IPC read with section 4 and 5 of PCMC within bracket Banning Act 1978. List this matter on 2015.
Third October.
3rd of October.
Let it be on, oh, just put it available, no?
3rd of
Or
20.
transport subsidy. How much time will you take?
Require much time. Usually the question is very short. But they have rejected, they said that you are not entitled to, because this earlier, there was a transport subsidy scheme of 1971. Thereafter, it was converted to the freight subsidy scheme in 2013. Our registration was under the 71 Act, but by the time we took the registration and all that in 2012, this new scheme came. So we could not establish our factory and all that, so we could not claim the subsidy and all. Now, in 2013, when the subsidy came, then it is there are clause 17 is there in this scheme that who are already registered under the 71 scheme are deemed to have been, the authority concerned will change their registration from the 71 scheme to 13 scheme. They did not do. In 14, we have written a letter that kindly do it. They have not done it. In the meantime, we have started our production in 2017, 27th of March 2017. Thereafter, we are raising our claims. Now, our claims, they say that we cannot be considered because the registration was done because I'm sorry, ultimately, they in 19, they registered under the scheme, saying that though it is registered in 19, it will relate back to 2013. That from 3/3/2012. Now, the authority says that since your registration, you started the production in 2017, and your registration was in 19, so you are not entitled in view of clause 8 of the scheme. My whole contention before this honorable court is that clause 18 does not apply so far we are concerned.
So according to you, clause 17 will apply.
Because
you are an existing thing under the previous
1971 transport subsidy scheme. Now, while filing the affidavit, they have took another year. That was not the ground of rejection, but it was taken in the affidavit of opposition. That in
2016, one notification came. And it says that, my lord, from 22nd of November 2016, the scheme will be closed. It will not continue. Though, my lord, as per the scheme, it has to be continued for a period of 5 years. But the central government decided that it will not continue from 22nd of November 2016. And whoever already got registered earlier, they can get the subsidy, no others. But that point was not, my lord, on that ground, the rejection was not there. This was taken.
When did you apply?
Well, we apply in 14, my lord.
14. And it was for any specific period or production was to be started when?
Well, it was said that it has to be started within the 5 years period from when the scheme starts.
Your scheme starts when? Started on 13.
Well, if need be, my lord, I'll take my lord too. But there is a sunset clause.
15, 16, 17. So 17.
18, my lord. It will continue to 18, my lord.
15, 16, 17,
My lord,
18. It was supposed to continue up to 18. But by virtue of the notification, it was closed in 17.
16, my lord.
16.
The sunset clause, my lord, clause 4, it says that, my lord, it will, my lord, terminate automatically after 5 years of the date of publication of this scheme. But the central government thought it fit. They said that no, it will not continue beyond 22nd of November 2016. Well, that is the basic case, my lord. Then I have to.
Are you proceeding for final disposal?
My lord,
then you will have to wait for some time. I have 2 part-heard matters.
No, there is no difficulty. We
Because-
are waiting. There is no difficulty.
Today or some other date? Today?
Any
Subject to-
date, my lord, if you allow, my lord.
So what I'm saying is that 2 matters are, this is a will not say new matters, comparatively new, 2022. Isn't it? Comparatively new. Other 2 matters are, one is in a important matter, in a admission stage we are deciding, it's a tender matter, and other is a old pending matter, I think one of the oldest.
We can have some other day.
Yes, my lord. I'm not there.
That's right. Okay, Mr. Das, how much time will you take? HK Das.
10-15 minutes. Madam.
Okay. Okay, then we'll give a date, give a convenient date.
Yes, a little bit of date, my lord.
As per your convenience.
Well, I'll just.
Yes, just give a date. We'll adjourn it. Kolita, give a consensus date. Yes, Mr. Das. 15 minutes, then we'll start Mr. Chaudhary case at 3:30. What is 21? Just wait for a minute. What is 21? Bishop.
Lordship, the judgment which the Lordship was referring to DC link, is it 2021-20 SCC 465 MC Mehta versus Union of India?
But you will kindly come to page 11 of the repetition at the very outset.
Page 11.
Para 7 of the repetition. What is the pleaded case of the petitioner, my lord? One paragraph only.
Paragraph?
Para 7, my lord.
Yes.
Page 11. That the petitioner respectfully begs.
Just a minute. Where is the
I'm sorry.
So many bundles of your written argument, judgments, what not.
Sorry for the inconvenience.
That is the writ petition.
Oh.
Page,
Page 11, para 7 of the writ petition.
page 11, para 7. Yes.
That the petitioner respectfully begs to state that the grounds and obligor reasons for rejection of petitioner's bid was labor license is valid for Kamrup Metro District only. The ground for rejection of the technical bid of the petitioner is non-existent and absolutely fallacious in view of the fact that the copy of the labor license, although indicated that the labor license is valid for Kamrup Metro District, however, the copy of the license categorically states that the said license is valid for undertaking the work of contract and supply in establishment of Directorate of Animal Husbandry and Veterinary Assam, a care of Senikuti, Guwahati, Kamrup Metro, Assam, meaning thereby the petitioner is eligible for undertaking any contractual work in the Animal Husbandry and Veterinary Department. Hence, the rejection of the bid of the petitioner on that count is absolutely irrational, not tenable in the eye of law. So by this, the petitioner is basically contending that he was enrolled with the principal employer, which is situated in the district of Kamrup. So since he was enrolled with the principal employer,
According to him, though license specifies a region, but he is entitled under, since it's a
yes,
principal, he work
principal
anywhere,
employer,
anywhere.
he is entitled to work anywhere. So I have searched the entire writ petition, my lord. Regarding the labor license, this is the only ground. Another ground taken is that the discrimination, that he was not similarly treated so far as allowing the additional document is concerned to the other tenderers. That is the another ground. These are the two grounds basically urged in the writ petition. Now I'll just take your lordships to clause 17, page 47 of the writ petition.
Page
47.
Page 47.
The submission was made that this labor license was not an essential condition. It was because lordship was taken to the section 6 showing the list of forms wherein the labor license was not there. So an argument was advanced that this submission of labor license is not an essential condition. Now, my lord, will kindly come to clause 17, documents establishing bidder's qualification. 17.1, the documentary evidence of the bidder's qualification to perform the contract shall establish to the employer's satisfaction that bidders meets each of the qualification criteria specified in section 4. So section 4 contains EPF and labor license. The penultimate clause is clause 2, capital A, Roman 3.
Which? Please tell us.
Clause 2, section 4,
Clause
comma, clause 2,
Section 4,
comma, clause 2,
clause 2,
capital A,
capital A,
Roman 3.
Roman 3. Page,
Page 55. So this was the clause under section 4, and clause 17 says that the bidders meet each of the qualification criteria specified in section 4, qualification evaluation criteria. The bidders should submit all required information
Yes.
and documents.
clause 3 is the important, up to date labor license
Yes.
and ESI.
So
I have
they,
already marked it.
yes, they say that that is not an essential criteria by referring to the list of forms, but from clause 17, it is apparent that that was one of the essential criteria for success in the technical bid. Now 17.2, bidders should submit all required information and documents and fill all the forms as prescribed in section 6 bidding form. Section 6 contains the list of bidding forms, Milo. So that was also one of the essential criteria. Now, my lord, will kindly come page 49, clause 30.
Please.
Page 49, clause 30. Lordship has seen this clause on the last occasion, Milo. Immaterial non-conformities in the bid.
Page 49.
Page 49 of the writ petition.
Yes,
Para
yeah.
30. The
Para?
clause 30 down below, Milo.
Okay, I this have seen.
Yes. So an argument was advanced that immaterial non-conformities in the bid means that the labor license was immaterial. Milord, in my respectful submission, Milord, that is not the interpretation of this particular provision in the clause, because this particular provision is the power given to the tender evaluation committee, that they can, and 30.2 is the clause which was exercised by the tender evaluation committee. So 30.1 gives the power and 30.2 is the manner in which they can do. And that particular thing has been done by the tender evaluation committee by searching for historical document, directing the other two tenderers to, my lord, clarify their position. Now, my lord will kindly come to page 50. So, clause 32.
Clause
32.
Yes.
Down below. Non-conformities, errors and omissions. 32.1. Provided that a bidder is substantially responsive, the bid evaluation committee may waive any non-conformities in the bid. Now, an argument was advanced on the last occasion that the petitioner's bid was substantially responsive, which is, in my humble submission, is not absolutely correct. Absolutely incorrect submission. The bid evaluation committee may waive if the bidder is substantially responsive. Now, Lordship has seen clause 17, wherein this particular labor license is one of the essential conditions. If it's an essential condition, and if you fail to fulfill the condition, that means you are not substantially responsive. So this reliance on this particular clause by the petitioner is absolutely, my lord, unnecessary. Then, my lord will kindly come to page 51, clause 35. Evaluation of bid. I am concerned with serial number E. Additional evaluation factors are specified in section 14, evaluation and qualifying criteria. It starts from page 35.2. It says to evaluate a bid, the employer evaluation committee.
Now we'll go to page 35.
No, sorry, clause 35. Okay. I'm sorry. Clause 35.2, my lord will kindly have a look. To evaluate a bid, the employer evaluation committee shall consider the following: A, B, C, D, and E.
E, I have read it.
Yes.
Additional evaluation factors.
So include section 4. So while evaluating the bid, the tender evaluation committee is under obligation to see what is there in the section 4, whether the parties have fulfilled the section 4 or not. Now, my lord will kindly come. Page 54. That is section 4.
Yes, page 50.
4.
Section 4.
Yes. This section contains all the criteria that the employer shall use to evaluate a bid and qualify the bidder. In accordance with so and so, no other factors, method, or criteria shall be used. The bidder shall provide all the information requested in the forms included in section 6 bidding forms. So section 4 is already there, and section 6 information is also to be provided.
4 are the essential criteria,
and formats.
6 are the only forms which we required. You may not give a form of license, but your license must be there.
Yes, that is there.
If you had a license, if you did not submit the form but declare it, then it could have been a responsive.
Yes.
This is your case.
Yes.
Understand?
Now
you want to make a distinction that there is a difference, marked difference between 4 and 6. 4 makes the labor license is an essential condition.
Yes, my lord.
And 6 only prescribes which we want. These documents we want. That will not necessarily make the certificate non-essential.
Exactly.
This is your case.
Yes, this is my case. Now, Lordship will kindly mark, need not read, my lord. Clause 1, it starts with evaluation of the bidder's technical bid. Lordship will kindly go through this, my lord. Now, a submission was made on the last occasion that he was not required to submit the labor license prior to award of contract. And even it was also submitted that he cannot even submit a labor license. Now, section 4 of the NIT mandated that submission of labor license is an essential criterion. Now he submitted the labor license. And now the petitioner is making a submission that he cannot submit the labor license.
Relatable to the work.
Relatable to the work.
He can submit any license, but he can, according to
Exactly.
him, he is required to take a
Two
fresh
things.
license.
He said two things. He is not required to submit the labor license prior to award of the contract. That was one of his submission. Second limb is that even he cannot even submit a labor license. That is the petitioner.
Labor license relatable to the work.
Work. Now, what my submission is that, my lord, since the NIT has mandated in section 4 that your submission of labor license is an essential criteria, and you have not challenged the NIT in
So you have to
question.
submit.
So you are bound by whatever terms set forth in the NIT, my lord. You now cannot turn around and say that I was not required to. If you are not required, or you cannot, you should not have submitted the labor license. And if the department insisted you that you submit the labor license, that you have, then you have challenged the NIT saying that as per the rules and all these things, I'm not required to submit. So having not challenged the terms of the NIT, you cannot raise that argument. Now, with regard to CVC guidelines, my lord, CVC guidelines were placed before your lordship.
CVC, let us not go
So
for a time.
in-
It's a, when
that
general
is also-
conditions are there.
Yes, in that even also, my lord, my submission is that had there been a genuine grievance with regard to, my lord, submission of labor license prior, then you should have challenged the NIT relying on CVC guideline. Like that, look at the CVC guideline. I'm not required to give you a labor license. Now, whether the condition of submission of labor license is a essential or subsidiary, that is already been established for section 4. Now, one submission has been made that principal employer is the in charge who are there in the place of work. It's not the office of Directorate of Animal Husbandry at Kamrup district. You know, I have some serious reservations with regard to this submission. You know, that is not correct. I'll just take your lordship to the scheme of the act for a moment. Contract labor regulation.
Just read it. We'll
Yes.
just recall it.
Yes. Lordship will remember establishment under the definition, establishment, Miller, there were two definitions of establishment. There is a reason behind that, Miller. If your lordships kindly take the act, it has two chapters, chapter 3 and chapter 4. Chapter 3 provides or make provisions for the principal employer to register before the registering officer.
Yes, two parts. One is registration, one is licensing. Two parts.
So chapter 3 provides for-
Registration is to the principal employee to
Yes,
register.
if a
And
principal
license is for the contractor.
Yes. If a principal employer, he wants to engage contract labor and he comes under the purview of the act, then he is bound to register before the registering officer.
Yes.
And so far as chapter 4 is concerned,
licensing.
it provides for licensing.
Yes, we have read
That if a contractor, he is required to engage
if he uses or he wants
Yes.
to use
Engage-
engage contract labor, then he'll have to take a license.
yes,
For
and
a
from the
certain time-
licensing officer.
From the licensing
two
officer
terms
to,
are
to
used.
ascertain that he will follow the norms of the act and rules.
Exactly. So principal employer and the Milord contractor. Now these two definitions relate to, in my respectful submission, one relate to the principal employer and another relate to the license, Milord, the contractor. Because definitions are, Milord, formulated in such a manner, a bare reading would demonstrate that one is related to the principal employer and another relates to the contractor. Now the rules, Milord, Rule 21(1) Rule 21(1) makes mention about the term establishment. It provides that every application by a contractor for the grant of license shall be made in triplicate in Form 4 to the licensing officer of the area in which the establishment in relation to which the contractor is located. So it is implied that the license that the contractor will procure has to cover that particular area wherein the work is to be done. Now, this
Let us not go to that.
no, that is my submission, my lord, because it is implied. That is my submission. Now, 21(2), the word establishment is in relation to the office of the principal employer. Because 21(2) says for furnishing of Form 5 with regard to the office of the principal employer. So, in my humble submission, the submission made by the petitioners on the last occasion that the principal employer would be the officer or the in charge in Sibsagar or where the work is to be executed is not correct, my lord. Principal employer will always be the director, my lord. Wherein the main
He has not
office,
said that.
no, that submission was made. my
You
lord.
want to say that principal employer is the
Director, as per the definition of the tender clause.
director of the veterinary. That's
Yes.
he also said. That is, there is no dispute. That's what I'm saying.
In fact, the
According to
tender
him,
clause
director is the principal employer.
I misheard, my lord.
Ah.
I perhaps misheard.
That's why that's what
Principal
I'm
employer
confirming.
is always the director.
Director. This
Yes.
is his argument. In fact,
Now-
that is the argument of Mr. Nath also.
Yes, yes, yes. So this establishment in 21(1) and 21(2), both are, the meaning of the establishment is different. First of establishment relate to definition 2 and second relates to definition 1 of the act. Now, one judgment I am relying on, my lord, which it's a constitution bench judgment which defines this establishment.
In respect to contract.
This particular act. My lord, in fact, this act was challenged. Validity of this act was challenged.
Paragraph?
I'm just giving, my lord, I'm sorry. Para 17 and 19, my lord.
Just tell us what it says.
Yes, a small paragraph, I'll just read. It will take less time than, my lord, explaining. 17, a contract under the act in relation to an establishment is a contractor under the act in relation to an establishment is a person who undertakes to produce a given result for the establishment through contract labor. A contractor is a person who supplies contract labor for any work of the establishment. The entire context shows that the work of the establishment is the work site. The work site is an establishment and belongs to the principal employer who has a right of supervision and control, who is the owner of the premises and the end product and from whom the contract labor receives its payment either directly or through a contractor. It is the place where establishment intends to carry on business, trade, industry, manufacture, occupation after the construction is complete. Now, para 19, my lord. The expression work of an establishment means the work site where the construction work of the establishment is carried on by the petitioners by employing contract labor. Every clause of a statute is to be construed with reference to the context and the provisions of the act to make a consistent and harmonious meaning of the statute relating to the subject matter. The interpretation of the word will be by looking at the context, the collocation of the words and the object of the words relating to the matter. The words are not to be viewed in relation to the whole context. The definitions of contractor, workman, contract labor, establishment, principal employer all indicate that the work of an establishment means the work site of the establishment where the building is constructed for the establishment. The construction is the work of the establishment. The expression employed in or in connection with the work of the establishment does not mean that the operation assigned to the workman must be a part or incidental to the work performed by the principal employer. The contractor is employed to produce the given result for the benefit of the principal employer in the fulfillment of the undertaking given by him by the contractor. Therefore, the employment of the contract labor, namely the workman by the contractor, is in connection with the work of the establishment. The petitioners are contractors within the meaning of the act. The work which the petitioner undertake is the work of the establishment. That was my precise submission from the very day one, that the work of the establishment is Sibsagar. Department has decided that we need a labor license which covers that particular area.
Milord, when the decision
Your
of a-
whole case is that they want what they require.
exactly, Milord,
So therefore,
they are the
they
author.
have, they have said what they require.
Yes,
Who is the read court to say that this is not they require, what they require is this? This is your case.
that is one aspect.
That is,
And-
you are relying on
and,
the.
and one more aspect that had he in Milord possession of any certificate with regard to Milord or certificate which covers Shivsagar, then Milord Article 14 would have come that I was not given an opportunity, Milord. There was no till date the certificate as of now he renewed. That is also for District Kamrup, Milord. So that is my submission, and one submission with regard, one judgment with regard to Milord, this grounds which can be taken whether
Which tell us.
whether if the grounds argued are not based on the pleadings, what will happen to those arguments are given in para 9 of this judgment. Milord.
We are not so technical in repetition.
No, fine, my lord. That is my. I'll not read, Milord. Lordship will kindly have a look, Milord. So, in my humble.
Can I take 1 minute, your lordship, before lordship? Kindly.
We have given you enough time.
No, I know that. Just quick reply to my learned friend what he has said. I'll take just 90 seconds. Lordship, the first thing, I'm sorry. I have not said that.
Milord, my humble submission, Milord, the grounds on which, pleaded grounds on which the writ petition, the NIT was challenged, Milord, those are not at all sustainable in the eye of law. The department has not done any mistake in considering the certificate or necessitating a certificate which covers that where the work is to be executed, Milord. There is nothing wrong in that. Milord, I have prepared one small little submission for your lordship's assistance, Milord.
That's good.
I'll just change the date, Milord. I'll just.
Why you require the date?
No, Milord, it's my duty.
No meaning of date.
No, it's my duty to put, Milord. When I was trained, we were trained like this. I have covered only those grounds which are pleaded in the writ petition, Milord. The rest, Milord, I have made submission. Lordship will kindly consider.
Yes, quick.
Your lordship, sorry.
Pankaj Mojumdar Enterprise was relied on before your lordship, Milord. Mojumdar Enterprise was totally in a different context. In Mojumdar Enterprise, in the NIT itself, there was a condition that the tenderer will have to submit the labor license after awarding of contract within 90 days. Milord, that facts and facts of the present case are not identical. Here they gave Form 5 on proposed to. So little difference in facts, Milord, makes different conclusion.
Of course.
And Puja Associates also in totally different footing, Milord. The facts were totally different in Puja Associates. No, highly obliged.
Your lordship, as regards the essential criteria of that clause which my learned friend has referred to, it is something I have not said that it is not required. But one cannot insist, the tender evaluation committee cannot insist me to submit it prior to the submission of the tender. Yes, prior to the submission of the tender with regard to experience and other relatable works in that district which I have submitted. Because the act, the rules and the judgment governing this field, it always says one thing. It has to be post-work and work specific.
That you have said already.
That it cannot be. And secondly, your lordship, yes, of course, tender evaluation committee are the best author for the bid documents, but they cannot form a cartel to curtail the rights of some other persons violating the Article 14, which is the core issue, your lordship, as has been said in Reliance and Faiz Ahmed.
Hearing concluded, judgment reserved.
Much obliged.
The most important thing and satisfying for me is that I don't know what happens. Yes, I have learned in this case. That's more important. Your lordship.
Mr. Das is there, everybody will learn.
Yes.
No,
Mr.
I don't
Das
know.
has done the role of the department also.
I don't.
A private counsel.
I am still to learn a lot.
We have given him a chance to assist us.
Yes.
No, it's always pleasure
Mr.
to
Nath
assist
is
your
also
lordship,
there. Yes,
Milord.
next case.
Highly obliged.
The department stand of it.
Yes, yes. Yeah, 1,000.
My lord, I made the argument on the premise that
Only
the
one point that.
very seizure itself is
Yeah,
bad.
yeah.
And my lord, in their show cause notice, they rely upon that regulation of 98. And in their affidavit in opposition, they say we are relying on MDG 2005, Marketing Discipline Guidelines. So my lord, in view of the honorable decision of the Supreme Court in MS Gill and prior to that, Gordon Das Bhanji, lordship will go by the show cause notice. Because by filing affidavit, you cannot improve your case. Now, lordship, my learned friend was supposed to inform your lordship, what does the procedure have actually followed?
Yes. My lord, the query that your lordship had put the other day, my lord, under what authority the anti-adulteration cell, my lord, inspects the retail outlet. May I please one document, my lord? This is, my lord, functional guidelines.
78. One.
Your lordship will kindly read the next page background. In October 04, Ministry of Petroleum.
You are
and
having a
Natural Gas-
copy?
No, my lord, sorry, my lord, I very hurriedly made only one copy. I'll only read 2-3 paragraphs from here, my lord, then I'll hand it over to my learned friend. In October 04, Ministry
What
of
is this QRC?
ORC, QRC means, my lord, Quality Reassurance Cell, which is my lord, renamed, which by which the anti-adulteration cell has been renamed. That is, my lord, reflected in paragraph 1 itself. In October 04, Ministry of Petroleum and Natural Gas advised oil marketing companies to set up oil company-wise their own surveillance cells. In Indian Oil Corporation, anti-adulteration cell was formed in April 2005.
In this case, it was done by AAC, isn't it?
AAC.
But the AAC name is still used by the IOC, my lord, instead of quality QRC.
When this was done in the year?
2012.
March 2012.
Okay.
The full-fledged functioning of the department started in April 2006 after strengthening manpower of its newly formed department. Later on, during June 18, the name of AAC was replaced with QRC. As directed by the Ministry of Petroleum and Natural Gas, functioning of QRC is independent of marketing division, and the reporting of the sale is functional director other than the director marketing. Now, what this matter shows that it is as per the matter advice of the Ministry of Petroleum that all marketing companies were advised to have their own surveillance cells. On the basis of that, my lord, these guidelines have been issued. Your lordship may also kindly read 1, 2, 3, 4, 5, 6, 7 paragraph. Nowadays, in retail outlet, adulteration of product is scarce. Short delivery is the major discrepancy being observed most frequently. Now, my lord, the modus operandi of the, my lord, my lord, retail outlets have changed. Then there is a chart given that may not be necessary. Then in the next paragraph, next page, your lordship.
It was issued when, this guideline?
This is an issue.
February 2021.
February 2021. But it was formed in, my lord.
No, that's true, but the AAC was replaced in the June 2018. This case is in the 2012. Whether this procedure will be relevant?
No, my lord, the question here is the anti-adulteration cell has been formed pursuant to the direction of the my lord, Ministry of
No, that I
Petroleum.
understand. See, therefore we say that there must be some either Mr. Chaudhary has argued that these are created by the ministry. However, to be in conformity with those act, a notification was issued in official gazette so that a person is authorized. Otherwise, it will
I'll come to
amount.
that, my lord.
Huh?
Now I am answering the query. What is the authority under which the anti-adulteration cell, my lord, inspection sources? This is answered in the first paragraph itself, my lord. Whether we use the name anti-adulteration cell or my lord Q or C, it doesn't make any difference. It was formed in my lord 2005.
2006, okay?
2005.
Okay, 2005. Under ministry, and therefore ministry has issued that notification, I think.
Ministry. Ministry has said to oil marketing companies including my lord Indian Oil Corporation.
What is that notification? This is.
No, I'll come to that notification. My lord. This is my first reply.
Okay,
reply to
okay,
your lordship first
okay. So
query.
according to you, this is their own procedure of the company, which has been formed in terms of the advice of the Petroleum Ministry. This is.
So, my lord, that is their my lord functional
So it is an
backing.
in-house anti-adulteration mechanism.
Separate from the marketing division.
Okay.
This is also important, my lord.
Okay.
Now, the next query that is put is that while following this, you have to come to the 2005 that my lord, the ministry, I mean that mechanism, not guideline. Thereafter, we follow the my lord guidelines, 2005 guidelines that we have followed. No, hey,
okay.
Not Regal Metrology Act. এখন এই স্কিম এর কথা কই আছে যে which and measure say 2005 or 2018 or দুখন আমি বিমান আছে then my lord we'll come to the my lord motor spirit and high speed diesel regulation of supply and distribution of prevention of malpractices order
1998.
1998.
Where do you get that?
I've given the other day, my lord. This
1998. Yes, yes.
Now the question that falls for consideration before your lordship is that, my lord, whether the procedure, what is the procedure to be followed? Whether section 100 of the CRPC will come into effect? And my lord, what is the effect of this order 1998 in view of the, my lord, the authority that has been given to the anti-adulteration cell, my lord, to inspect and my lord, and find out, my lord, what is the illegality committed by a dispensing unit, I mean a retail outlet.
Okay.
Now, so far as the order 1998 is concerned, I have, my lord, brought to your lordship notice on the last occasion that this is regarding, my lord, if your lordship goes by the name itself, motor spirit and high speed diesel regulation of supply and distribution and prevention of malpractices order 1998. This leads to malpractices. We are concerned with the malpractices, and malpractices has been defined in my lord, clause 2E.
Yes.
Clause 2E, my lord, gives as many as 9, my lord, headings under which the malpractices fall. Here, my lord, unauthorized fitting is not included in the malpractice. This is important in view of the fact that, my lord, if it is not a malpractice, the fact here is that, my lord.
Just a minute, let me note it down.
Yes, ma'am.
Yes.
The factual position is that anti-adulteration cell went there with a surprise visit, and in the surprise visit, my lord, in 2 dispensing units of the retail outlet petrol pumps, unauthorized fittings were found. And thereafter, my lord, following the guidelines, marketing discipline guidelines, my lord, we have taken action. This is our case.
Okay.
Now, my submission with your lordship is that this motor spirit order 1998 relates to malpractice, and my lord, unauthorized fitting is not in the definition of the malpractice.
Okay.
Then, my lord, my learned friend
Hmm.
relied on, my lord, clause 3C, capital C.
Clause,
That will be at the third phase.
third phase,
My lord.
clause 3C.
Sorry, my lord, clause 4C. Clause
Clause
4C,
4C.
power of search and seizure.
Just a minute.
It
Clause
starts with
4C.
clause 4, power of search and seizure.
Mm.
C, your lordship will read, the provisions of section 100 of the Code of Criminal Procedure 1973 relating to search and seizure shall, as far as may be, apply to searches and seizures under this order. So, my lord, my first submission is that, my lord, this order does not apply into the facts of this particular case because it was a, my lord, unauthorized fittings found in the.
Some addition,
And
foreign.
that is not, my lord, in the, my lord, definition. And my lord, now I'd like to try to, my lord, satisfy your lordship that section 100 of the CRPC does not apply. For that, my lord, I'll take your lordship to the CRPC. এখন CRPC দিও।
CRPC.
I'll take your lordship to the, my lord, introduction first.
Okay.
Where this, my lord, CRPC procedures apply. Introduction, may I read, my lord?
Yes.
The Code of Criminal Procedure 1973 contains 484 sections and 37 chapters and 2 schedules. This code is the main legislation on procedure for administration of substantive criminal law in India. It is a procedural law, provides for the procedure for punishment of offenders under criminal law. The Act provides for what process to be followed in every investigation, inquiry, or trial. My lord, the case in hand does not relate to any investigation, inquiry, or trial. That is my submission, which, my lord, I'll fortify from, my lord, reading to other provisions of the CRPC.
Yes.
Your lordship may kindly come to section 91. Section 91, chapter Roman 7.
Section 91.
Process. Has your lordship got it,
Yes.
ma'am? Process to compel the production of things.
Yes.
So, my lord, the under this chapter, section 100 also comes. Therefore, we start with the, my lord, main provision. This chapter deals with process to compel the production of things. Section 91, summons to produce documents or other things. Whenever any court or any officer in charge of a police station considers that the production of any document or other things is necessary or desirable for the purpose of any investigation, inquiry, trial, or other proceedings under this code by or before such court or officer, such court may issue summons or such officer a written order to the person in whose possession or power such documents or things is believed to be, requiring him to attend and produce it or to produce it at the time and place stated in this summons or the order. Now, my lord, I pause here for a while. Your lordship will read the first sentence again. Whenever any court or any officer in charge of the police station considers the production of any document and other things necessary for any investigation, inquiry, trial, or before the bench, so such court may issue a summons. So, my lord, there has to be a criminal proceeding. And under the criminal proceeding, my lord, either the police or the magistrate will issue a summons. Now, my lord, so far as the, my lord, the malpractice they have done, fitting, my lord, unauthorized fittings in the, my lord, dispensing unit to reduce the supply. We had two options. We could lodge an FIR, or we could have filed my lord, a complaint petition, or we can go under the marketing discipline guidelines. We did not resort to the criminal proceedings because, my lord, our guidelines
mechanism is there.
Mechanism is there with us, and my lord, the dealer is bound by the agreement as well as the marketing discipline guidelines. So unless, my lord, we file an FIR or any other person files an FIR, and unless there is a, my lord, summons issued by the police or the magistrate, my lord, there is no question of resorting to these procedures. Your lordship may then also read, my lord, section 93. When any court has reasons to believe that a person to whom a summons or order under section 91 or a requisition under subsection 1 of section 92 has been or might be addressed will not or would not produce the document or thing as required by such summons, then where such a document or thing is not known to the court to be in the possession, where the court considers that the purpose of any inquiry, trial, or other proceeding under this code will be served by a general search or inspection, it may issue search warrant, and the person to whom such search warrant is directed may search or inspect. So it is again, my lord, the court. Now, let us come to, my lord, section 100. Section 100 says, persons in charge of closed place to allow search. This is the heading. Thereafter, my lord, that particular clause is, my lord, there where there has to be an independent witness on all. Now, the petrol pump is not a closed, is not a closed place. It is a public place where any person can go buy petrol and diesel, and this is not a closed place. So all this together will perhaps satisfy your lordship that, my lord, section 100 has no application here, and it may have or may not have, it may have an application if there is a criminal case. Even then also, my lord, this is not a closed place. Therefore, the provisions of CRPC 100, section 100 is not attracted when we did not lodge any FIR, or nor any person has lodged any FIR or complaint. Now, there is one sentence, my lord, which may be a little confusing, which says that to the extent it in 4C of the, my lord, 4C no, of the order 1998. I have read it, my lord. I'll read it once again, my lord.
Yes.
The provisions of section 100 of the Code of Criminal Procedure 1973 relating to search and seizure shall, as far as may be, apply to searches and seizures under this order, if it is applicable. Where, my lord, this is not applicable here. So this is the, my lord, in brief, my reply to the first query regarding, my lord, the search and seizure. It has been done in accordance with the marketing discipline guidelines. They have been given show cause notice. They have given reply. The seizure was made in presence of the owner, and, my lord, they have put their signature. Then, my lord, sufficient opportunity was given. Personal hearing was given, and thereafter, my lord, the impugn order was passed. Your lordship will kindly read the impugn order. I'll only read the part of it, my lord, which relates to this particular query. Impugn order, your lordship will find in an additional affidavit in the writ petition. It was not filed, my lord. Perhaps at that time they didn't have the copy. By an additional affidavit, my lord, we place the order of termination. Then they, perhaps your lordship read it a little.
The idea the other day was the lordships will hear. I never advanced any argument on the.
We are not.
I'm also not. I'm only reading to this particular query only. On my other points, I will not argue unless you argue. Now, your lordship has your lordship
Additional affidavit.
Additional affidavit, my lord.
Satyabhrata Lohkar, law officer.
In fact, my lord, it was filed. It was filed as an, my lord, application to place on record the copy of the termination order.
That IA.
এইগুলি রেজিস্ট্রেশনে কি বলি রেজিস্ট্রেশন হবে না? Do you have a copy?
Impugn order.
তোমার আছে না কপিটা দিয়ে না?
No, no, photo আছে।
আছে।
12/7. Come to my 12/7/30.
Which one? Okay. It was there. I have seen on last occasion. Somewhere it is there. Some IA. Yes.
My lord, in the reply that they had given to the show cause notice and also in the personal hearing, my lord, very many points were argued. My lord, that I am not touching. I am touching on this particular point, my lord. The order is dated 12/7/2013. A brief note has been given, what has happened, then your lordship may come to page 6.
Page 6, yes.
The fourth paragraph.
Page 6 of the order, internal page.
No, my lord, in the internal page, my lord. In the order, it is in the second page, my lord.
In the order, it is in the second page.
The summary of your contention. Fourth paragraph.
The alleged device manipulating.
The summary of your contention are as stated above, and the later was as follows. My lord, the other points, since he has not argued yet, my lord, I am not arguing. Your lordship will come to serial number 3. There are no anomalies or discrepancies in the retail outlets as alleged in the communication dated 24/3/2012. The AAC team has no jurisdiction under MDG 2005 and is not empowered to make the inspection. This is the ground, one of the grounds he had taken, and that has been dealt with at the next page. I just want to bring to your lordship notice, my lord, what is the stand of the IOC. Your lordship will find different headings. Your contention number 3, because that was contention number 3. You have claimed that since a plethora of laws like Petroleum Act 1934, Weights and Measures Act 1976, MHSSB Control Order, Essential Service Maintenance Act, etc. already exist, hence implementation of MDG 25 is outside the ambit of law. Corporation submissions. The MDG 2005 that the corporation implements on its dealership network is neither a negation nor a contradiction to the existing statutory laws and regulations. Finally, MDG 2005 does not bar a dealer from taking recourse to any legal measures for safeguarding his interests. So this was the contention they had advanced on this point regarding the search and inspection. And that was the stand. Other points have been, my lord, taken care of in the impugn order. We have not read the entire impugn order as such because, my lord, my learned friend argued only on the point of the search and seizure.
Okay.
And my lord, in fact, relied on a decision of this honorable court, Nivedita Roy, my lord. If necessary, I'll place before lordship, my lord, that no law has been laid down there. The matter has been remanded back to the appellate authority only by the division bench.
By the division bench. That was division bench judgment.
Oh, that was a single judge.
Okay, then.
Single judgment has been set aside and it has been referred to the, my lord, the appellate authority again. And when it was before the appellate authority, the client was not in, my lord, the dealership was not interested to continue with the dealership, said, I don't want it. Maybe, my lord, that land can be used for a better purpose. In fact, my lord, there are many, my lord, dealerships in Guwahati. We have taken action against them and they were happy with the action because that land can be used for, you know.
What will they get by selling petrols?
In my lord,
Instead of making it shopping mall.
in my lord, this Adabari itself, my lord, there are 2 plots. They said we don't want it. Now, my lord, the big malls have come there.
My lord, my learned friend is making argument against his own action. Please come to page 54 of the writ petition.
54.
I'm very surprised. Now he is abandoning this 98 order. His MDG is is Bible now. Please come to page 56.
56.
Yes.
Hmm.
Allah, the show cause notice starts at page 54.
Hmm.
Please come to page 56.
Hmm.
4B.
Hmm.
The officials of anti-adulteration cell are authorized as per dealership agreement based on which retail outlet dealership is operated. Furthermore, AAC officials are empowered under clause 4A of the Motor Spirit and High Speed Regulation of Supply and Distribution and Prevention of Malpractice Order 1998. Now, how come, my lord, when the show cause notice says we have taken the action under this provision, an argument can be advanced, my lord. That's why, my lord, in MS Gill, the Honorable Supreme Court, let's kindly note that 1978, 1 SCC 405,
1978.
1 SCC 405, para 8. The proposition is, my lord, public order publicly made has to be construed in the context in which it is made. It cannot be understood by virtue of some subsequent explanation given in the affidavit. So it has to be tested on this touchstone. So, my lord, there is no dispute that they have done. They themselves proclaim that anti-adulteration cell is competent to take the action. Now, my lord, kindly come to that 1998 order for a moment.
Hmm.
Please come to 4A, because they say under this provision they have done it. Any gazetted officer of the central government or the state government or any police officer not below the rank of Deputy Superintendent of Police, duly authorized by general or special order by central government or a state government, as the case may be, or any officer of the oil company not below the rank of sales officer may, with a view to securing compliance with the provisions of this order, for the purpose of satisfying himself that this order or any other made therein has been complied with. So, my lord, an officer to be specified in the gazette. Now the gazette has been placed. It is the minimum rank is, I have placed the gazette the other day, my lord.
Yes.
The gazette is dated, my lord.
17th January.
Yes. So for so-and-so, the central government authorizes joint director of anti-adulteration cell established by Ministry of Petroleum and Natural Gas as authority to exercise the power of search and seizure under the order. So, as per this order, joint director alone can do. It has not been done by joint director. That's the end of the matter. Now, please come to down below, my lord, at 4C. The provisions of section 100 of CRPC relating to search and seizure cell, as far as may apply to search and seizure under this order. My lord, this is
Is relatable to 1, 2, 3, 4, and 5 prior.
everything. My lord, this is legislation by incorporation. Who is saying that, my lord, CRPC will govern everything? Nobody says. This is what is called legislation by incorporation. The procedure which is followed or prescribed under section 100, 3 CRPC will be applicable in such cases. And for that, we need not go to the CRPC to say that CRPC only applies to investigation, inquiry, and trial. There's a fallacy in that argument, my lord. It's a legislation by incorporation. I can adopt a particular provision from a particular act that authority has done. Now, how can the argument be advanced that CRPC will not apply in this case because there is no affair? Well, this is absolutely misconceived. It's a pure and simple case. The procedure prescribed in 100 CRPC.
Section 100 is applicable in CRPC when 94, 95 under that chapter. And section 100 is, according to you, made applicable in terms of section 4 to the provisions of while they carry out 1, 2, 3, 4, and 5.
Yes.
Absolutely. So therefore, to argue that the CRPC is meant for something else, we are governed by something else, that is not correct. Now, my learned friend has made a submission that this 1998 order does not contain any provision in definition of malpractice regarding that finding those. I mean, my lord, this 99 and A was replaced by 2005. And in 2005, there is provision, my lord. Same thing. They are aware of it, my lord. Yes. Kindly have this. my lord.
2005.
Yes.
Adulteration means introduction
madam,
of any
motor-
foreign substance
For a motor spirit.
into motor spirit.
Yes. So, no, my lord, it will be governed by this, not by the one my learned friend is referring.
Okay.
Kindly see, motor spirit and high-speed diesel regulation and supply, distribution and prevention of malpractice order 2005. And 1 second. And if your lordship will,
Short delivery.
short delivery is now introduced in the definition of, and their allegation is short delivery.
No.
100 and, well, lord, the entire finding is short delivery, that it results in short delivery of 140.
He says, just to understand, he says that infusion of some foreign particles, not particles, foreign mechanism is not adulteration. According to you, that is not
leads to short
important.
delivery.
According to you, that is not necessary. When it is short delivery and your allegation is short delivery, it is included.
Yes.
This is the debate.
Now, my lord, kindly come to order 7. Order 7.
7.
Yes.
Yes.
Any gazetted officer of the central government or state government or any police officer not below the rank of deputy superintendent of police, duly authorized by general or special order of the central government or a state government, the case may be, or any officer of the oil company not below the rank of sales officer, may, with a view to securing compliance with the provisions of this order and for the purpose of satisfying himself that this order or any order made thereunder has been complied with, or there is reasons to believe that all or any provisions of order has been are being or about to be contravened. Now then, my lord, this is the power. Now please come to 2.
2.
While exercising, next page, power of search and seizure provided under C and D above, the authorized officer shall record in writing reasons for doing so, etc., etc. Then 3, provisions of 100 CRPC relating to search seizure shall as far as may apply to search and seizure under seizure under this order. So same provision is reiterated. Now, most importantly, please come
Only
to 10
definition,
below.
there are some changes.
Below.
Only some changes in the definition.
Yes. Now
And
please come to
F1 is
10.
deleted.
Now please come to 10, Milord.
10.
Yes.
It is up to 8.
I'm so sorry. 10 is not there, Milord.
Not there.
Maybe one page is left out. Well, I'll give Milord. I'll give my copy, Milord. Overriding effects.
Yes, yes. Over there is already another. This is a part of your bus.
Okay. Please come to 10, Milord.
Hmm.
The provisions of this order shall have overriding effect, notwithstanding anything to the contrary contained in any order made by the state government or any officer officer before the commencement of this order, except as respects things done or omitted to be done that before such commencement. So there is an overriding effect. Now, my lords, having regard to all this, now does it lie in the mouth of IOC to contend that we have taken action under MDG 2005 by stating in the affidavit? Number 1, an officer below the rank of joint director has done it. He could not have done. That's the end of the matter. My lord, this is not our submission. that for resorting to any malpractice, I am not liable. All that I am saying is, while you investigate the allegation, I am being provided with certain procedural safeguards. Those safeguards you have denied. Therefore, it is violative of Article 14 because the equal protection of law has not been extended. Therefore, it's a case where power of judicial review is available. It's a simple case, my lord. I don't think any much argument is required on this.
Suppose we are failed your contention.
Yes, my lord.
Suppose,
Yes.
then I'm asking Mr. Chaudhary, is it the end of the
Yes,
this
it's
case,
a matter because
or
No.
we'll have to
demand it. No.
proceed? No, not going. Proceed further on the other aspect of the matter.
If I succeed in the first point,
Ah.
then my lord, everything goes.
No, that is what we want from Mr. Chaudhary. And suppose we do not uphold your contention,
Then Lordship will hear on merit.
then we'll have to hear on merit.
On that only, my your lordship is right. If my lord, he succeeds in this point, then my lord, there is no question of going into the other fact.
Merit all
And
facts.
because my lord, we have taken some grounds like then appeal lies, you did not prefer an appeal. And but then my lord, if your lordship wants, my lord allows me to give some clarification. Because my learned friend was saying that I am arguing against what the action that we have taken. And for that, my lord, he had referred to the show cause notice, showing that we have taken action under the, my
No,
lord.
you will argue that first line is, you will have to read both the lines.
My lord, this line is not, this is not the, my lord, provision under which we have taken action. For the, my lord, the provision under which we have taken action, your lordship has go to the, my lord, the order impugned of, that is the order of termination. Here, my lord, this is a narration of the, my lord, points he, because before that, before this show cause notice also, my lord, there were communications and he had taken some points. And
Specific
those points, my lord, in this particular, my lord, 4C, 4B, what the IOC says, the officials of AAC are authorized as per the dealership agreement based on which the retail outlet dealership is operated. Furthermore, AAC officials are empowered under clause 4 of the Motor Spirit High-Speed Diesel Regulation of Supply and
Which
Prevention
page you are
of
reading?
Maintenance Order 1990. We only say page 56.
Okay.
Page 50, we say, my lord, they are empowered. But this is not the, my lord, clause under which we have taken action. For my lord, the clause under which you have taken action, your lordship has go to the impugn order. There we have clearly stated, my lord, why you have taken this.
Impugn order page.
An order that additional reply.
Okay, that's final decision.
They are taken the grounds and why you have been terminated. We have given the clause under which violation of which you have been terminated. Not because, my lord, we have taken action under AAC. What we say is that the anti-adulteration cell is empowered under the, my lord, that prevention of malpractice.
Okay, let us do the thing like this way. We are fixing this matter again, maybe on Tuesday or Wednesday. On that day, we'll if we deliver, go in your favor.
End of the matter.
End of the matter. If we don't go, then we'll carry.
Yes. My lord, on the point of appeal, it says, my lord, there is a direct Supreme Court on petrol pump case only. I'm giving the citation, my lord. 2003 2 SCC 107, paragraph 7.
Can you give me the?
Yes, I'm giving copy, my lord. Paragraph 7, it deals with that point only. 2003 2 SCC 107.
Okay.
Has been assigned, my lord, in the writ petition as to why did not they prefer an appeal.
Please this matter for further here, hard in part. We'll just fix it for further hearing. We'll apply our mind. At 4:15, I do not want to dictate this order. Okay. Then I may be out of station for Saturday and Sunday. So
Lordship, I have it on Wednesday or Thursday, my lord, not Tuesday.
Wednesday. List this hard in part, list this matter for further hearing on Wednesday.
Highly obliged.
By sleep, huh? Give this file to me. I'll just go through. Yes, and one matter is there, I think. Yes, what is this?
Akshay, it's an application under Article 226. It's a tender matter. We were given a parcel van on lease.
Mm.
And subsequently, there was COVID lockdown.
That
where-
COVID and all.
Yes, we were unable to operate.
No.
And subsequently, we have also notified the authorities twice on 2 dates. Before that, may I be allowed to submit a submission? On submission.
Now, what is the present status?
Contract already over.
Hmm.
Contract period is over. Yes, Lordship, one they have stated that that they may be blacklisted for future contract, but that possibly Lordship is cannot be in this case, Lordship. And I have to talk with them that their case is that whatever is in the impugn order, the action is that much only. For future, they cannot at this stage. It will
What
be
is the prayer in this writ petition?
My lord, the prayer is continuation, to allow continuation of the contract because
Contract is already over.
yes, period is over.
Lordship, the contract is
Last-
not for some construction. it
Are
is
you
for
arguing
parcel
seriously in
land.
this matter?
Lordship,
Okay, argue.
the contract was not for any construction which comes to an end. It was for parcel van, loading, unloading of parcel van. And the clause that they have stated for our termination is clause 20.4. That if the leaseholder fails to operate the contract continuously for 10 days without giving notice. However, we have given notice that
Okay,
stating
there is some
reasons-
other day. Due to paucity of that matter could not be taken up, this matter,
On 24 or
after puja.
Lordship,
Nothing.
an interim order was given before.
Okay,
that
list
we
this matter. After puja vacation. Interim order pass earlier shall continue till then.
Okay, right.